sentence start, it is fact. Have you lordship got my lord?
Yes, yes.
It is fact that the Fair Dealer is not interested for issuance of the digital ration cards. However, so they are admitting that I have no role to play. And I have shown, however, it was the duty of the distributed ration card to the actual beneficiary who will appear before the with the DRC. Mere existence also. If a family member comes and say I have 10 cards, can I deny the ration articles of 10 family members? The authentication only in respect of the particular person who is coming the shop. This is the only consideration, no further consideration. He has admitted.
Mr. Shara, why did you disburse more than what was produced before? If one ration card is produced, you have to disburse that much amount.
The law says, control order says, if a family member comes to me along with the ration card office, all family members, I have to distribute to all card holders by authentic identification of only the member who is coming to me.
Was that portion of the control order? Was that provision in the control order?
There was no such provision. There was no such provision that everybody has to come. Because at that material point of time, authentication was going on. Aadhaar setting was going on.
Mr. Shara, at least if I go for taking withdrawing the ration of my family, then I have to take at least all the ration cards belonging to my family members. That is the process which is followed in every ration shop.
Before completion of the Aadhaar setting, the procedure was
we are speaking about before that. Prior to this biometric system, what used to happen is the whatever number of persons are there, all the ration cards had to be taken for the disbursal.
Yes, that was the system altogether. Any member may come, even other family before digital.
One member may come, but not with his own ration card. One member may come, but he has to bring all the ration cards against which it is to be distributed.
Yes, I have to distribute. But
so you have followed that method only. Even if one member comes, he has to produce all the ration cards against which the disbursal is made. So you say the other members I could not verify because all the members did not come. Very well.
This is not the procedure. Now your lordship kindly come to opposition, which they have filed.
Opposition to
come to. I have annexed.
Oh, acha. What is that?
That page, my lord, 95. Just one paragraph I shall read, page 95.
Yes.
But kindly turn to paragraph 28 at page 112. What is their case for principle of natural justice is concerned? One paragraph. Page 1 page. Running page 1 paragraph 28.
Yes.
That with reference to the statement made in paragraph 22, I have stated that you have not supplied me any document. I say that it is denied that the non-supplier physical copy of complaint, kindly take note of, and inquiry report is not so important as the discrepancies and allegation found during inquiry were clearly indicated in the show cause notice, where facts are explained. So, my copy of complaint has never been supplied, report has never been handed over, person who has allegedly been interrogated, that list has never been supplied to me. I don't know who have been interrogated. Total violation of principle of natural justice. And this is a case made out by the state. Now, your lordship, kindly see page 127. The report has been annexed with the affidavit, which has never been supplied to me, only in respect of kindly take up that. It starts by kindly turn to my page 127.
Yes.
But that if you also kindly come to the copy of the complaint, which they have also annexed in their opposition, which starts from page 160. But this is a person, Pradiptan Ganguly, who lodged the complaint advocate, which they have annexed only in the opposition. He is a resident of Siliguri, right-hand side. My dealership at Hashidawa, which is 35 kilometers away. And more so, he is not my consumer. It starts from page 116. Now, your lordship, kindly come to the report, which they have annexed also. At page, my lord, just a minute. 127.
Yes.
Kindly see the date. 1st February 2024. This is the report allegedly they have received from the deputy director. It has never been handed over to me, only in the opposition. And kindly come to my lord, page 48, date of show cause notice. 14 May 2024 at page 48. So this report has been submitted on 1st February. On consideration of the same, show cause notice has been issued at 48, 14th May. Am I correct? Now your lordship kindly see first paragraph, how they have proceeded, presumption and assumption. Number of AIC have been lordship in paragraph 1. I'm reading on a paragraph 1, page 127.
127, yes.
Number of AAY digital ration card is given in the Excel sheet shared by the reform cell. Instead, kindly take note of, instead of AOI family, hence, exact calculation of family entitlement drawn is not possible.
Oh, আচ্ছা।
assume করো না, নিজেরই বলছে তো not possible.
Oh, you're frozen. Your picture is frozen. You are taking advantage of that time to go through this report. হ্যাঁ, assumption এর উপর ঠিকই বলছি। For the ease of calculation, para 2 দেখুন। কিসের বেসিসে আছে?
Hmm. 1, 2, 3 তে apparently assumption হয়ে যাচ্ছে।
Next page. Kindly see page 128. Page 128, calculated the punishment. For issuance of your lordship, kindly turn the final order, page 48. This is the punishment which has been paid before issuance of the show cause notice. Is it permissible, my lord? The deputy director says the total punishment through court 3,61,000. Kindly turn to page 48. This has never been supplied to me. Page 48 is the final order.
Page 48?
8 is the final order. The same amount in the report.
Final order at page 52. Page 52 is the final order.
My lord, 52, sorry. Kindly come to page 54. What is the punishment?
Yes.
And tally with 128. So before issuance of proceedings, issuance of show cause notice, determination has been made. What will be my punishment? My specific case to save the skin of the food officials. I have no role to play. Same amount. On the basis of this decision, show cause proceedings are initiated. Whether I have filed my submit reply, whether there is a first appeal or second appeal, immaterial. They have decided the issue in the month of January and May show cause notice. It's totally eyewash. If there is an audit, the Food and Supplies Department have to answer why you have issued those number of ration cards, why you have tagged it, why you have delivered. What is my role to play? A dealer, it is a mandate upon him to deliver the ration articles on production of ration cards if one of the family member comes and gives his biometrication by thumb admission. There is no denial.
Mr.
In
Chara,
anywhere.
sitting in this jurisdiction, we won't go into the merits of the adjudication, but definitely regarding the process, you have a strong case. 2 or 3 grounds, if you can sum up, and please add whatever you have to. One is that the report was prepared prior to the show cause notice. No copy was given to you. That non-supply of copies this serious point was not considered by either of the appellate authorities. First. Secondly, it was a pre-decided issue because the calculation even was made in the report and that was reflected. And lastly, that it was based on assumptions because it assumes that 5 members per family and all this, and it is admitted that it could not be calculated.
And
so based on assumption is another issue. Yes. What else?
Adding one line, copy of the complaint and name of the ration card holders who have been allegedly been interrogated. That has also not been supplied. The copy of the complaint is the main thing. Initiation of post, root of the post. Copy of the complaint, they have stated some ration card holders have been interrogated, but I have not been given any list who have been interrogated so that I can chase them or I can bring them in during the postings.
The complaint itself refers to some persons having been interrogated. The complaint says.
No. Complaint is Pradipto advocate.
Their order says.
In the show cause notice, it has been stated that the deputy director interrogated some of the beneficiaries. Random. The sentence is random. Not all.
Yes.
That names of cardholders who have allegedly been interrogated has never been supplied, so that I can contact them and say why you have not said so.
You would have a vendetta against them. Probably that's why their names are not supplied. Obviously, if you have clout in the area, then you have a ration card dealership means you have some clout.
They have never gone to any cardholders.
So these are sometimes this is not a civil suit or a disciplinary proceeding even. So the persons, there may be secret complaints, but what is to be reflected in the order is the specific reason for that.
Yes.
Reasons have to be given and based on, other principles of natural justice. Very good. Let us hear Mr. Mishra for the others. Yes, Mr. Mishra.
So to begin with, we would once again have a look at the so-called notice that was issued to him at page 48.
We are stuck there actually. We are coming back to it every time. So that's open.
No, I will end at page 50.
No, not your fault. That has to be seen.
Oh, my lord.
So we are there only.
So there was a complaint that was lodged.
Yes.
What was the complaint about? The DRC number in your FCS is 17,314 in February 2022, which was reduced as on May 2024. So initially there were a lot of ration cards that were attached. Some of those ration cards have been delisted from there. 7,022 DRCs were deactivated. Upon interaction with the DRC holder during field inquiry, it was found that such deactivated cards were in duplicate and DRC holder is getting his or her ration entitlement on their original DRC, which they possess, and they had no knowledge about the deactivated DRC in their name. So one person, there were multiple DRCs. Now what has happened is the moment there is an Aadhaar seeding that is happening, then in that case, because this is all, there is a leakage in the supply system. So that leakage in the supply system, it gets covered because then based on the Aadhaar setting, only the person who is entitled to the food supply will get the food supply, others they will not get it. Many DRC holders stated that there was no such member in their family in the name of deactivated DRC, and they had no knowledge about those deactivated DRC included in their family. So there are two situations. One is, even in case of a proper DRC and their family, duplicate cards were there, and then there are cards which belongs to head of the family and the members of the family that does not even exist. Regular monthly allocation.
How can he be responsible? How can they be responsible for the duplicate cards?
I will come to that.
Issued by the rationing authority only.
No, we will come to that. We will come to that.
Yes.
Regular monthly allocation were made by the department on those deactivated DRCs in various months starting from the issuance of the DRC. So from the authorities, allocation was done. But at the end of the day, milords, it is the final point or the bottom point from where the actual segregation upon different verticals has to be done, and that, milords, is the FTS dealer.
The end of the chain.
Yes, that is the end of the chain. Now, if I can have milordship for a moment on the reply at page 50. What have they said?
Yes.
In paragraph 3, they say, after the introduction of the DRCs for food grain has been delivered to all of those beneficiaries was produced DRC, that is a typo. At the time of drawing of the ration.
Who produced? It is who produced?
The DRC.
Yes.
It says, after the introduction of DRCs, the food grains has been delivered to all of those beneficiaries was produced.
Who? That's who.
Who produced DRC at the time of drawing of the ration.
Yes.
At that time, we all know that the food grains have been delivered to the beneficiary by not doing biometric authentication in full-fledged manner. So there is an admission there. He further admits in practical field. So he is now showing the practicality of how things would happen. In practical field, the one family member of the family usually comes to draw their full family ration. So it is not possible for the FPS dealer to identify the ghost beneficiary among them, because on the one hand, the non-biometric authentication of the beneficiary, and on the other hand, so he is blaming it on the supply department. Paragraph 4. It is surely said that all the beneficiary got food grains on the production of their DRCs at that time before the introduction of Aadhaar authentication in full-fledged manner. This is not the question whether all the beneficiaries, they have got the food grains or not. This is a question wherein those who are not the actual beneficiaries, whether they have been supplied or not. That nuance has been substantially missed here. So it is not possible to ascertain how many actual members consist of one family at that time. This nuance is the reply. Para 5. After the deactivation of DRCs, the allocation of food grains lying with me adjusted to following months. That is after the supplies has been done to bogus, to fake, and to genuine beneficiary. He is talking about that. Now he is not going back. As per norms of FCA department, DRCs has been issued by Food Supplies Department only after the request of the applicant by submitting proper application form. So I had no knowledge about the using of deactivated cards, where they are coming from, reactivated card till date. Then what the authorities have held. I understand that this order that is there at page 52, which has been passed by the licensing authority, being the sub-divisional officer, it could have been arranged properly. The first page
that it's
could have gone to the last, but the crux remains, at page 53.
Yes.
On the scheduled date and time, the hearing of the FCF dealer was started, and deposition of the FCF dealer was recorded in hearing sheet. So an hearing opportunity, proper hearing opportunity was given at the very first opportunity.
Audio alterum partem was not violated.
Was not per se violated. The only ground they are making is the copy of the complaint, and the copy of the inquiry report was not served upon them.
Inquiry report, that acquires importance, Mr. Mishra, because that inquiry report contains detailed calculations and even the amount. If that was because the final order is a reproduction of that.
My humble submission to that would be,
which was even prior to the show cause notice.
Yes, in TT Koni versus SEBI, it was said that when there is an inquiry report, that inquiry report has to be submitted.
Submitted here, it acquires more importance because it's a in total reflection of that inquiry report.
I understand that. I understand that.
The calculation.
But there is also an exception to it. The exception says that if there is an admission that has been made, and based upon that admission, the only consequence that could have been achieved is the steps that has been taken.
No. There are several conjectures and surmises. It's admitted by the authority that it cannot be calculated how many people were given, but still it proceeds on certain assumptions. We don't find any basis for that. It is assumed that there are 5 members in a family.
That has to be done as a ballpark figure on a random calculation.
Ballpark figure has to have some basis.
The basis is there.
5 persons per family. Where do you get it? Because and moreover, these specific grounds taken of non-service of report not adverted to by either of the appellate authorities. Not adverted to. If there was an adjudication on that, Mr. Mishra, we understand fully, and writ code definitely does not go into that. Merits we cannot go into. But 2 or 3 violations of basic cardinal principles, not audio alternative partem, we can understand per se, as you say.
But even if the inquiry report and the complaint would have been given to the accused person, then also, the consequences would have been the same.
That, Mr. Mishra, there may be a dispute regarding that, because it's not that the prejudice test, which you are saying. They would not be prejudiced without that service.
Yes.
But
so it is a technical thing that they are taking.
We would have admitted that. I mean, would have accepted that. But here, Mr. Mishra, the report is the very basis of the entire calculations. And the entire calculations, the coming to the figure, the basis of the calculations, everything is based on that report. So the final penalty imposed on him is entirely based on that report. No copy is given. There is nothing else in the orders apart from that. First. Second is, that's why it acquires importance. It's not unimportant. Secondly, Mr. Mishra, now this, and it was pre-decided prior to the show cause notice. That was, the calculation was even made, that is reproduced in the final order.
No. I said that it should have been placed at the fag end of the order.
No. The report was.
The impression would have been a different impression.
Not that. The report, the date of the report shows it preceded the show cause notice even. So therefore, that report was arrived at immediately after getting the complaint, We don't say for the report also, authoring the report, you had to give them a hearing. No. But then, if the report is already there when the show cause notice is issued, you have it with you. It should have been a part of the show cause notice itself, not at the time of hearing. That is the premise of your entire show cause notice, your entire order. First. Secondly, the appellate authorities, neither of the appellate authorities, first appellate authority is virtually a reproduction of this, second is the reproduction of the first. Anyway, there are certain differences, paraphrasing.
The second appellate authority has dealt with reasons, my lord.
Reasons are given in both. Reasons are given in both.
Yes.
But you do not advert to their reply. It's a lip service paid, such as non-service of copies of this complaint as well as the report. What is the basis of framing of charges? They have to be told the specific. See the show cause notice also. Show cause notice, Mr. Mishra, is very vague, we find, which has not been categorically argued as such by Mr. Shara. Please come to page 48.
Yes,
Please come to the premises that regular monthly allocation were regular monthly allocation were made by the department on the deactivated DRCs for the various months, starting from the issuance of DRCs till the deactivation of the same.
Yes.
Now, you proceed on the presumption that as per record, 6, no DRC holders from the list came forward for reactivation since long, which clearly indicates that those were not in existence. Now, this presumption you are jumping to conclusion in the show cause.
Because they were fake and bogus.
Just because they were not reactivated subsequently, you
There
cannot
was no
say.
entity or no person by that DRC.
No, at that point of time, there was a valid DRC. There was a valid.
There was an issued DRC. Whether it was valid or not, that
You issued, your authorities
yes,
issued.
there was
They
a
had
issue.
no role to play.
there was an issued DRC in
There-
favor of a non-entity.
You did that. So
Malashya.
take action against your own officers who issued those DRCs. Why them? They are scapegoats actually.
No, they are the one who have distributed the ration.
They
At the-
distributed on the basis of a rational basis, ration on a rational basis. Because Mr. Mishra, they verified the ration cards produced by the family members. I mean, we know because in our younger days, Mr. Mishra, you know, all of us have seen, I mean, you might not have taken ration at any point of time.
I have taken mine.
But all of us have taken. Because we have gone to the ration shop, we have to produce all the ration cards of the family members, then only it's disbursed. Otherwise, it's not distributed. আমি 5 জনেরটা নিয়ে গেলাম। সেটা বলছি না, বলছি ওই একজন যে গেছে ওই 5 জনকে একসঙ্গে যেতে হবে, ওদের সবার অস্তিত্ব না ভেরিফাই করে 5 জন যায় না কখনো, একজন নিয়ে গেছে। না না, একটা এগেন্স্ট দুবার হয়েছে বলছে না, ডিআরসি গুলোই ডুপ্লিকেট, রেশন কার্ড গুলো ডুপ্লিকেট বলছি। রেশন কার্ড ডুপ্লিকেট, ও কি করবে? রেশন কার্ড তো ইস্যু করেনি, ও কি করবে? ওর কোনো রোলই নেই। অলরেডি ইস্যুড রেশন কার্ডের উপর রেশন যাবে। His duty was to verify the ration, that whether there is a valid ration card.
Also, actually, this process wherein one person goes and he carries for the entire family members and the ration for the entire family members.
Have you ever seen a line queue before the ration shop?
No, this is not part of the order, my lords. This is for the sake of convenience that it happens. That every family member hasn't to come.
No, but
the moment there is allegation regarding bogus and fake ration cards being there and ration cards being
what
entered
is
into
their role in this? You are saying that they were deactivated subsequently. Now they are sitting here.
Their role, my lords.
Suppose I am the ration shop
Yes, ma'am.
without identifying with the ration
Yes,
shop
ma'am.
owners. So you are the DRC holder. They are the authority. They issue DRCs to you. You come to me. My job is to just verify whether there is a ration card. I am not an expert in whether it's a manipulated document or whatever. Authority has issued, you bring it to me, I disburse. Subsequently, you say that those were deactivated and the ration card holders did not come back to deactivate. That shows that those are not in existence. Suppose subsequently, even you did not know at that point of time, before deactivation, that those were duplicate, those were false. How is the ration card owner supposed to know?
Page 53 for a moment, Mars.
53.
3, 4, and 5.
Yes.
And then the bottom
Yes,
comments that are
yes.
there.
3.
As per the inquiry report, DRC holder did not know about existence sitting with Aadhaar. Then to whom the FCF dealer had served the ration entitlement. The FPS dealer replied that he gave ration entitlement to full family to the person who carried those DRC, and the DRC holders told lie about the possessing of duplicate DRCs. So he is playing an active role there.
What active role? He gets the
says
DRCs.
that the beneficiary is lying. At least that is
because
there.
the allegation is made, he says that how do I know that they are
Then
lying?
let's come to 4 and 5.
Yes.
The FPS dealer had shown distribution to ration commodities against those DRC through unauthenticated mode from EPOs despite the implementation of the Aadhaar-based system. First allegation, and the second is also there in 5. I will come to that.
Aadhaar-based system, exactly when was it introduced? With this 2023, this...
Yes, and still he was supplying from the EPOS system without Aadhaar-based. And then in 5, there is a non-withdrawal register that has to be maintained. If I can have my lordship for a moment on 5. Why the FPS dealer did not deny issuance of ration commodities to the doubtful DRC holders, and while non-withdrawal register not maintained against the DRCs. This is the specific role that this person has played. Then the FPS dealer replied the same, that he gave ration entitlement to full family to the holder of the ration card. It was difficult for him to identify, and then the conclusion is there. It was observed that during the whole process of hearing, the FCF dealer was in denial mode and kept on blaming the Department of Food and Supplies for the misdeed committed by them, violating
Exactly, because you issued those
yes.
DRCs.
But it is clearly mentioned non-transferable at the face of every DRC, which means the DRC holder cannot transfer his or ration entitlement to another person, and ensuring that the DRC holder, that the person in whose name, age, and other details mentioned in the DRC is getting the actual ration. That was violated. Then let's come to the next.
But
page.
you are going beyond the show cause notice. The show cause notice does not say any of this.
Everything will not come in the show cause notice. No?
Show cause notice has to indicate the exact charge.
When he replied, then Milords, this is the...
No, Mr. With due respect, show cause notice has to mention the exact charges. Exact charges what I am facing.
Yes.
Show cause notice says regular monthly allegations were made by the department on these deactivated DRCs. So up to this, your fault. Regular monthly allocation was made by the department. So you issued the duplicate DRCs. You
0.7 of the show cause notice.
Yes, you disburse the allocations against them, and you subsequently deactivate them. They are not reactivated. So you say he was at fault for having disbursed the ration during that period against valid ration cards. How does he know whether they're valid or not?
7 and 8 of the show cause notice, not for a moment.
7 and 8, yes.
The distribution of PDS commodities shown against the various categories of dubious DRCs from the date of activation of such DRCs to the month of deactivation, as per the entitlement scale of the respective distribution months, have been calculated accordingly, multiplying the quantity with the average cost of acquisition for that year. 8 is important. The distribution shown in the name of deactivated DRC also was deviation from the PDS commodities by the FPS dealer.
Now, this
He
is
has deviated from the practice that was there.
deviation
After the Aadhaar authentication was there, and after the...
So you said deviation of PDS commodities. Deviation from what? Of the
deviation from two things. One is Aadhaar seeding has already happened, so that has to be taken care of. And second was the withdrawal register has to be maintained.
We find that the Aadhaar not issuing the against the Aadhaar is the most important allegation.
Yes.
Because the other one is based on your 6. 6 is you are jumping to conclusion. No DRCs were reactivated. Therefore, those are not. No, 7 is based on 6. Because those were not in existence, and therefore
non-withdrawal register and Aadhaar. These are the two allegations that we have in the
non-withdrawal register. Where do you say that? That
is also from 8. That is coming from 8. That is a deviation.
Because the name of deactivated basis is deactivated.
Yes. If we read this 8 along with page 53.5, 0.5 at page 53.
0.5, yes.
Yes. Did not deny issuance of asset commodities to doubtful DRC holder, and why non-withdrawal register not maintained with such DRCs. This is also part.
But they were not doubtful before their DRC was deactivated. How could they be doubtful at the relevant point of time? They had activated other ration cards.
So there are two kinds of DRCs. One is DRC in which Aadhaar is seeded. Another is DRC in which Aadhaar is not seeded. So the moment somebody comes in which Aadhaar is not seeded, then Milords, at least that has to be maintained in the non-withdrawal.
Admittedly, those were active before they were deactivated.
So for that lame duck period, where is Milord that
between
deactivation and active in the middle of that, then in that case there was a non-withdrawal register that has to be maintained. That was not maintained.
Non-withdrawal register is not even mentioned in your show cause notice anyway.
So that Milords is 0.8. That would be covered by.
What is deviation? The distribution shown in the name of deactivated DRC holders was deviation. That distribution in the name of DRC holders was deviation. So by dint of their being deactivated subsequently, that you constitute as deviation of PDS commodities by the FPSD. You don't say that it was given to duplicate holders or whatever. They had
During
no.
that lame duck period, Milords, what happened was 5 of the order.
It says the distribution shown in the name of deactivated DRC holders was deviation. By itself, it was a deviation. But that point of view, it was not
Before it got deactivated, yes.
Before deactivated, it was not deactivated. So how can that be a deviation? You say 6, these follow each other. 6 says no DRC holder came for reactivation, which clearly indicates that those were not in existence. So this is the first mistake in the show cause notice itself. It cannot jump to that they did not come for reactivation does not necessarily mean those were not in existence, because by deactivating you are admitting that those were activated. I cannot deactivate something which is not active. So are we clear on that? So we cannot deactivate something which is already not active. So therefore, if it was active at that point of time, it was not in existence or not, they were not supposed to know. Second, you say the distribution of PDS commodities shown against the various categories of dubious DRCs from the date of activation to the month of deactivation. So you treat those subsequently deactivated DRCs as dubious because of their subsequent deactivation and non-reactivation. So during the period of activation, between activation and deactivation, they could not have been said, you even did not say they were dubious because they were active, they held active DRCs. So that is the seventh ground. 8 is the distribution shown in the name of deactivated DRC holders was deviation of PDS commodities by the FPS dealer, causing huge loss. I mean, these are too big. Because of the subsequent deactivation, you are holding him responsible. If you say, yes, non-roll register was not mentioned, say that in your show cause notice specifically. You did not maintain registers properly. There is not a single allegation regarding everything is premised on subsequent deactivation. Therefore, they were not in existence. And you went on supplying to them and against those categories because those were subsequently held to be dubious. So everything is premised on their being deactivated subsequently, which is entirely your authority's fault, not you, your fault, the present authority maybe, but the licensing, the rationing authority, the license issuing authority, their fault. Ultimately, it's the state. So your premise is that these allegations, we don't find them, that they did not maintain proper register. Could have been said one line.
In the show cause itself,
in the show cause, it has to be there. They did not even know what they were fighting. They were fighting against ghost allegations. It says that distribution shown in the name of deactivated DRC holders was deviation of PDS. It never says that you did not maintain register properly. They might have taken the registers to you. How do you know they did not maintain these registers? They were not given any opportunity. At the hearing, they are confronted with the question that whether you have the withdrawal registers. These are new grounds. That is what we are saying. Your best ground, still we say, is Mr. Definitely that why didn't they follow Aadhaar after it was implemented? Because it was implemented. This came as per Mr. Shahara also. This amendment came on 29th of September 2023.
And still they were following the
they were following the system. Partially. Their allegation is partially their defense. So that we have some doubt. But up to that we can understand, Mr. Mishra. But then the imposition of this, what is the premise of the assumption? Tell us. That calculation, 5. You are saying that you...
Their Milords, what they have done is, they have taken the kg of allocation that is there and they have multiplied it
come to that once
with the base price.
You can come to that also. We can come to that. The decision which is now.
This is page
127.
52. 157, yes. Sir. 127 and 128, Mr. Mishra. That is the report. No, let us see the order itself. The appellate authority's order is there.
Fine.
No, it first appears at page 52, what they are talking about.
52.
The quantum of fine.
First appellate authority, page 68. And second appellate authority.
52, but Mr. Mishra, there is no basis given for this calculation.
There is no basis given. For
no basis.
Then
the first appellate authority does it.
The order of the first appellate authority.
Yes,
the order of first
it gives a
68.
basis.
68, page 68.
There also the basis is not there.
No, there also it is not there.
It is not there.
It is not
it
there.
Simply says, by dissatisfied with the response, such and such amount was, and
yes,
he agrees with the amount.
Therefore,
then comes the second appellate.
Second appellate authority does not also give that breakup.
That breakup is not there, but the second appellate
now
authority
you see, you do it without any breakup. Now, if surprisingly, if you come to the report, that gives the breakup and the amount is exactly the same. Let us check. Yes, it is exactly
because the order has been upheld by both the authorities. The amount has to be this.
Mr. Mishra, the order does not reflect any basis whatsoever. It's
for the fine.
for the which is where the shoe pinches. So neither of the orders, three orders, none of the three orders mentions the breakup at all. Just quantifies the fine and says that you have to pay this. That breakup is only available in the report which you did not give a copy to him. And let us see that report. Therefore, we have to revert back to the report now to see what is the whether that is at page 127.
Yes.
Now, if they had a copy of this report, they would have known the reason for the breakup also. You don't even the orders don't even blindly rely on the report. They don't even rely on the breakups. They directly go to the quantity. So it's beyond blind. See number 1, for example, Mr. Mishra, page 120 is given in the Excel sheet shared by the reform cell instead of AI family. Hence, exact calculation of family entitlement drawn is not possible with current data.
Because that is something that is fluctuating.
Understood.
Then,
so assuming 5 members family, which one of us how many of us have 5 members in our family now?
No.
Next line.
That.
So assuming. Next line.
But today, Milords, their only
Mr. Shah is adding to the effect.
Today, Milords, their only premise is that the copy of the report and the copy of the complaint was not handed over to them.
Yes, we are wondering whether we have to set aside the appellate authority's order, because 2 grounds primarily. Aadhaar is a good ground. They did not follow that biometric system. Up to that, it's fine. But then the quantification, this breakup quantification, at least they had to be given a hearing on this report. Now they have a copy of the report. This has been given. You need not give them further, but they can argue on this and then come to an adjudication. You come to a finding, but that has to go back to the first authority. That is what we are.
That has to go back to the SCN now.
That is our next question, whether it would help you more if we set aside the SCN.
We will set aside the entire.
Do you understand what we are saying? Well, with this SCN, if you do this exercise, again you will be castigated.
Press SCN.
Press SCN.
He is the culprit.
So you're doing that right now.
It's not controller.
No, the difficulty is Mr. Mishra is he knows where to stop. Therefore, we lose the killer instinct altogether.
I've been on that side more than I have been on this side. So
Yes.
I understand how.
Therefore, for fair people, the difficulty is Mr. we lose our edge. I mean, we can't say anything to you.
No, I cannot justify something which is not justifiable.
No, I think it will be better if you do it properly.
Yes.
We understand there are several serious allegations against them.
The order of the Honorable Writ Court, along with the order of the First Appellate Authority, the order of the
Everything.
everything
We have to
was
set
then
aside
set aside
5,
5 orders,
6, with including the show
the
cause.
SCN, yes. And we will be given the liberty to proceed de novo
I'm good.
from the SCN stage.
Anyway, let us do that. Please take your seat, Mr. Mishra. Yes. And Mr. Shara, you have been sitting, so you may stand now if you want. The present appeal has been preferred against the judgment dated May 22, 2026, passed in WPA 1113 of 2025. Full stop, next para. In the said writ petition, the present appellant had assailed an order of the second appellate authority, affirming those of the first appellate authority and the licensing authority in terms of the West Bengal Public Distribution System within bracket maintenance and control bracket closed order, 2013 square bracket for short, referred to as the 2013 order, double inverted square bracket closed, full stop. Next para. Learned senior counsel appearing for the appellant contents that the impugned orders of the 2 appellate authorities and the licensing authority were vitiated by several infractions of principles of natural justice, which were overlooked by the learned single judge. Full stop. That apart, it is argued that the learned single judge apparently proceeded on the premise that the appellant had disbursed essential supplies against deactivated DRCs, whereas the plinth of the allegations against the appellant, leveled by the respondent authorities, was that the disbursals were made during a period when the said DRCs were still active. Full stop. Next para, learned senior counsel contends that a complaint, comma, which was the genesis of the show cause notice and referred to therein, as well as a report which was the very basis of the order of all the authorities, was never supplied to the appellant. Full stop. Despite such point having been raised before both the appellate authorities, comma, it was never adverted to by the said authorities. Full stop. That apart, comma, it is argued that in the show cause notice itself, comma, the licensing authority referred to interaction with DRC holders and a field inquiry, but no particulars of the persons who were inquired was ever supplied to the appellant, comma, nor was any opportunity to confront those people by cross-examination or otherwise, comma, was afforded to the appellant. Full stop. Next para, learned senior counsel next argues, next places reliance on the copy of the said report, comma, which was annexed to the affidavit in opposition filed by the respondent authorities to the writ petition, comma, which gives a purported breakup of the penalty ultimately calculated against the appellant. Full stop. However, comma, it is submitted that the said calculations were entirely based on conjecture. Full stop. Next para, for example, comma, in the first paragraph of the report dated February 1, 2024, comma, it was mentioned that number of AAY caps AAY space caps DRC is given in the Excel sheet shared by the caps reform cell instead of AAY family, comma, hence তারপর italic say exact calculation of family entitlement drawn is not possible with current data. Italic শেষ, full stop. Thereafter, comma, the report proceeds to assume that there were 5 members per family per AAY DRC holder. Full stop. Next para, thus, comma, such surmise and conjecture invalidates the report, comma, which again was the basis of the impugned orders. So next para, even in the orders of the authorities, comma, it is pointed out that no breakup or method of calculation was furnished, but surprisingly, comma, all the authorities arrived at the exact amount of penalty that is reflected in the report. Full stop. It is further pointed out that the report itself was authored even prior to the show cause notice, and as such, the show cause notice was premeditated, and the entire exercise of giving a purported hearing to the appellant was an eyewash. Full stop. Next para, learned AAG appearing for the state opposite, learned senior counsel appearing for the appellant further submits that the show cause notice was based on alleged offenses committed under paragraph 19 clauses within bracket 12 and 16 of the 2013 order. Full stop. Next para, however, comma, the said clause was introduced with its current amendments only with effect from September 29, 2023. Full stop. Next para, during the initial teething period, comma, it is submitted that the verifications at the time of disbursal to the DRC holders was being made partially on the basis of biometrics and partially by physical mode. Full stop. Next para, it is submitted that this was the prevalent method throughout the state, and as such, the appellant could not be blamed for the same. Full stop. Next para, even otherwise, comma, it is submitted that the very basis of the allegations against the appellant is that the activated DRCs which were issued to the holders thereof were subsequently deactivated by the authorities themselves, comma, in which the appellant did not have any role to play. Full stop. However, comma, by the basis of such post facto deactivation, comma, it was retrospectively deduced that the disbursal prior to the deactivation was also vitiated, comma, which is submitted to be a travesty of justice. So next para, learned triple AG appearing for the state defends the impugned judgment as well as the orders of the authorities. Push up, it is pointed out from the show cause notice itself that the broad contours of all the allegations on the basis of which the appellant was held guilty were disclosed in the show cause notice itself. Push up, learned triple AG submits that the show cause notice need not disclose the details of every offense committed, but is required only to disclose the rudiments of such offenses which were done in the present case. First up, it is submitted further that item 8 of the show cause notice categorically mentioned that the distribution shown in the name of deactivated DRC holders was deviation of PDS commodities by the FPS dealer Abdul Hakim, bracket present appellant, bracket closed, comma, causing huge loss to the government exchequer. Whose of next para, thus, comma, the indictment of the appellant on the ground that the register of the non-drawal register not being maintained was indicated in the said clause of the show cause notice itself. So furthermore, comma, even after the Aadhaar card verification system came into operation, comma, the appellant continued to distribute supplies on the basis of the manual method, comma, which had become obsolete, which itself comprises an offense under the 2013 order. Which of next para, learned triple AG takes the court through the orders of the appellate authorities as well as the licensing authority and submits that a detailed hearing was given to the appellant. Moreover, comma, deposition of the appellant was also recorded in the hearing sheet. Learned triple AG places reliance on the order of the licensing authority imposing penalty on the appellant, from which it is shown that the authority adverted to all the points argued before it by the appellant. Next para, thus, committee submitted that in the absence of infraction of any principle of natural justice or any law, comma, the writ court could not have entered into the merits of the adjudication, comma, nor can this court, comma, sitting within the limited scope of an intra-court appeal, interfere with such observations. Next para, upon a perusal of the materials before us, comma, we find certain
serious prejudice were caused to them because of
right. Thank you. It is further submitted by learned triple AG that the prejudice test is not met in the present circumstances, comma, since non-service of the complaint or the report on which the authorities relied did not cause any serious prejudice to the appellant, comma, as the appellant got adequate opportunity of meeting all the allegations against him. Next para. However, comma, upon hearing learned counsel for the parties and adverting to the materials before us, comma, we find certain serious infractions in the methodology of the respondent authorities. First, comma, the charges leveled against the appellant in the show cause notice dated May 14, 2024 were somewhat vague and different from those on which the appellant was held guilty. Next para, within the four corners of the show cause notice, comma, for example, comma, we do not find any allegation that the appellant was not maintaining non-drawal or any other sort of register, comma, the mention of which could very well have posted the appellant with the information that he was required to meet such allegation and, comma, if necessary, comma, to bring such registers if available. Next para, even otherwise, comma, the essence of the show cause notice and the following allegations flow from item 6 of the same, comma, which mentions that no DRC holders from the list of deactivated DRCs came forward for reactivation of the DRC since long. তারপর double inverted, which clearly indicates that those were not in existence. Double inverted close, full stop. Proceeding on such basis, comma, in item 7, it is stated that the distribution of PDS commodities shown against the various categories of double inverted with the dubious, double inverted close, DRCs, comma, from the date of activation of such DRCs to the month of deactivation, comma, as per the entitlement scale of the respective distribution months have been calculated accordingly, multiplying the quantity with the average cost of acquisition for that year. Full stop. Again, comma, item 8 mentioned that the distribution shown in the name of deactivated DRC holders was deviation of PDS commodities by the appellant, causing huge loss to the government exchequer. Full stop. Hence, comma, the very premise of the alleged offenses of the appellant was the fact that initially active DRCs were subsequently deactivated. Full stop. Next para. However, comma, the function of issuing DRCs as well as activation and subsequent deactivation of those were entirely on the part of the respondent authorities, and the distributors had nothing to do with it. Full stop. Distributor stroke fair price shop owners had nothing to do with it. Full stop. In the present case, comma, the appellant was merely a license holder for a fair price shop and had no role to play either in the issuance or the reactivation or subsequent deactivation of the DRCs. Full stop. The appellant, comma, as such, comma, apparently acted on the DRCs produced before him at a juncture when they were active, and as such cannot be blamed therefore. Full stop. Next para. However, comma, there is substance in the argument of the state that the continuance of supply on the part of the appellant, even partially, comma, after the implementation of the Aadhaar card and electronic verification system might have been a cause of concern. Full stop. Moreover, comma, there are other aspects of the matter, comma, such as issuance of supplies, such as disbursal of supplies to persons without maintaining a non-drawl register might have been an offense under the 2013 order. Full stop. However, comma, such discussion enters into the realm of conjecture in the absence of any specific allegation in the show cause notice itself on such specific counts of non-maintaining of registers, etc. Full stop. Next para. Another important aspect is that the report itself, comma, which is the sole SOUL of the impugned orders of the authorities, comma, and the only basis of calculation of the penalty, comma, was dated February 1, 2024, comma, thus preceding the show cause notice dated May 14, 2024. Full stop. In the orders of the licensing authority and both the appellate authorities, comma, not a single sentence have been devoted towards indicating the breakup as to how the calculations were arrived at. Full stop. However, comma, the ultimate quantum of penalty imposed tallies exactly with the report dated February 1, 2024, comma, thus reflecting a premeditation on the part of the licensing authority at the juncture of issuing the show cause notice itself. Full stop. Next para. The impugned orders of the authorities are also vitiated for non-mention of the basis of breakup, comma, which robbed ROBBED, the appellant, from an opportunity to argue before the authorities as to the veracity of the same. Full stop. Next para. Although from the report itself we find that certain conjectures and surmises were resorted to for arriving at the calculations, comma, since despite having been admitted by the authorities that it was not possible with the current data to calculate the family entitlement, comma, the authorities assume that there are 5 members per family without any reasonable basis, comma, we stop short of entering into the merits of the same, comma, since it will be prejudging the issue, comma, which comes within the domain of the authorities and not this court sitting in appeal. Push up next para. Be that as it may, comma, be that as it may, comma, in view of the report being the very premise of the impugned orders, comma, non-supply of the same to the appellant prior to the along with the show cause notice also assumes significance and definitely prejudiced the appellant seriously. Push up thus, comma, the prejudice test, comma, contrary to what is submitted by the state, comma, is squarely satisfied in the present case due to non-furnishing of such copy. Push up also, comma, for all, in all fairness, comma, the copy of the complaint, which was the very genesis of the show cause notice, also had to be given to the appellant for giving him an opportunity of a proper opportunity of hearing. Push up next para. Moreover, comma, the appellate authorities did not advert to several grounds taken by the appellant, comma, including the cardinal question of non-supply of the documents referred to above. Pushed up next para. Thus, comma, in view of there being assumptions and conjecture galore in the decision-making process itself, comma, the said process is vitiated due to violation of principles of natural justice and arbitrariness as well as perversity. To sub next para, also, comma, as discussed above, comma, the show cause notice is vitiated due to non-specificity as to the exact offenses which were ultimately the basis of imposition of penalty against the appellant, as well as the deviation between the grounds taken in the show cause notice and the grounds on which the appellant was held guilty vitiates the entire process from the show cause notice upwards. Push up next para. These factors were apparently not considered by the learned single judge. Push up with utmost respect, comma, the learned single judge also took into account that even during, even after the deactivation, comma, the supplies were last sentence next para. In such view of the matter, comma, we are of the opinion that the judgment impugned before us, as well as the orders of the appellate authorities and the licensing authority and the show cause notice suffer from serious and incurable infirmities. Pushed up thus, comma, those cannot stand the scrutiny of law. Accordingly, MAT 53 of 2026 is allowed on contest, comma, thereby setting aside the impugned judgment dated May 22, 2026, passed in WPA 1113 of 2025, as well as the
show cause notice May 2022.
No, we'll go backwards, as well as the orders dated March 11, 2025.
The first appellate authority, page 68, 13 September
68,
2020.
Comma, September 13,
2024.
Yes. September 13, 2024, comma, passed respectively by the second and first appellate authorities, as well as the order dated July 8, 2024, passed by the licensing authority,
The show cause
and
notice,
quashing the show cause notice dated May 14, 2024. Push up next para. However, it is made clear that nothing in the above observations shall preclude the respondent authorities from initiating the entire process from the stage of issuance of show cause notice against the appellant by following due process of law. Full stop. It is expected that in order to avoid further lacunae in the process, the respondent shall also annex with the show cause notice all relevant documents and materials on which the respondents wish to rely on. Full stop. Next para. Consequentially, Can 1 of 2026 is also disposed of. There will be no arrest to cause. Urgent certified copies. We dictated in open court because otherwise reserving it would serve no purpose. We don't have many days left. So there may be certain defects in the order.
Single page notice has been handed over to them. I mean, that is there in the order, but specifically, let that also be.
Which one?
The 2 crore 36.
Mr. Mishra, we are not here to advise you, but better when you start the process afresh, annex everything. Annex everything. Otherwise, this will be repeated. Judgment, it is judgment. Appeal, judgment. Final disposal of it. We'll come back and resume with the next one.
Much of it.
এটা তো ওর বেসিসে
By an order dated June 11, 2026, it was recorded that an adjournment was sought by the appellant and a last chance was given to the appellant to argue the matter. For next para, even today at the time of call, none appears to argue the appeal. Accordingly, SAT 13 of 2024 along with CAN 2 of 2024 are dismissed for default without any orders to cost.
Last chance they are to go.
Item number 7.
Lord, I appear for the appellant. I appear for the appellant.
What is the matter?
Yes.
Mr. Bhattacharya?
My lord, this is my lord, admission under order 41 rule 11.
Yes.
There was a restoration application which was already allowed by your lordships. Now
Right.
What happened, my lord? This is a suit for declaration of title and permanent injunction. Now, my lord, my suit has been dismissed by both the courts. Only, my lord, trial court dismissed it. If your lordship would kind enough to see, not dismissal in, my lord, totality, only declaration part has been given. Permanent injunction and recovery of possession has been refused.
Why?
My
On what
lord,
ground?
the court says that the schedule is vague. Court cannot pass a decree which is unexecutable.
And appellate court said because schedule is vague, declaration should also go.
No, appellate court mechanically affirmed the order. My lord, if your lordship
Appellate court affirmed that order. So
Affirmed that
declaration
order.
remains.
Declaration remains. If your lordship would kind enough to come to, my lord, the trial court
Huh.
judgment page 14, issue number 7 and 8.
Let us come to that first.
7 and 8. My lord, that is the only, my lord, all the issues have been decided in my favor for declaration, but recovery of possession and permanent court says that
But then how could declaration be given? We are also setting aside declaration.
my lord, if your lordship would kindly see, my lord, the chain deeds, my lord, I was successful in proving the
Achha.
chain deeds. Court
7 and 8.
May I place, my lord, these two issues?
Yes.
These two issues are taken up up together at the path of the discussion in the interwoven with each other. Till now, in view of the above discussion, no impediments can be found in the path of the plaintiff of getting a decree in his favor. So far as the discussion regarding whether the plaintiff has right title and interest in the suit property, the in broader aspect is concerned, all the questions got affirmative answer for the plaintiff. But when it comes to the threadbare discussion, thereby a gloomy picture floated from the evidence on record. There is no doubt that the vendor of the plaintiff acquired title in respect of 16.5 decimal of land vide the deed of gift executed by Jyoti Sharma on the strength of the deed of sale number such and such of 2012. The title in respect of 16 decimal of land passed to the plaintiff. So there is no doubt about the title of the plaintiff in respect of 16 decimals of land. But the question remains whether where is the 16 decimal of land located. The vendor of the plaintiff acquired title in respect of 16.5 decimal of land comprised in LR plot number 710, 711, 712 and 713 by deed of gift number 5183 of 2006, but she recorded her name in the LR record of rights in respect of 16 decimals of land comprised in 2 plots only, that is 711 and 712. According to the deed, she had right to sell 16.5 decimals of land from those 4 plots, not plots, not from any 2 plots amongst 4 tantamounting to 16.5 decimals. The schedule of the deed of gift of the schedule of the deed of gift of Mayarani Sharma is itself a vague one, because it does not disclose how much land is gifted from the and from which plot, and the evidence in this regard to remove the vagueness of the schedule of the deed is also not permitted given the bar under provided under section 93 of the Evidence Act. Her 16 decimal of land might have been recorded in the record of rights under 2 plots of land. But
Mr. Bhattacharya, you have seen it. Yes, court is right in a sense, because which portion has been given? How can there be either eviction or injunction? Share was it was not demarcated as to which exact 16 decimals were given to you. What is the wrong in this?
I am only one submission, my lord. If your lordship would kind enough to, my lord, see order 26, rule 18, capital A.
Right. FCPC টা দিন। Yes.
My lord, kindly see, my lord, the provision of this order shall apply so far as maybe to the proceedings or execution of a decree or order. My lord, I subject to correction, I have a chance in the, if I get a decree, my lord, I have a chance, my lord, in the execution case to apply order 26, my lord, for demarcation by a, my lord, commissioner for recovery of possession.
Now that is the question, Mr. Bhattacharya. If you seek demarcation at the time of execution, wouldn't that be beyond the decree? That is also what we were thinking, that at the time of execution, whether the court can say at the time of passing of the decree that it will be, but this is per se, ab initio it will be inexecutable if a decree is passed.
Yes.
If a decree, an inexecutable decree, whether it should be passed, I mean, even otherwise, suppose, how does 16A help you, Mr. Bhattacharya? Let us read 16A.
18A, order 18.
Sorry, 18A. Let us read 18A.
The provision of this order shall apply so far as may be to proceedings in execution of a decree or order.
Agreed. That you can do.
Yes.
But you cannot have a partition unless you seek a partition in a suit.
My lord,
Commissioner can go and identify. Yes, we can understand. But what will the commissioner do if the deeds themselves do not say which portion has been given? It's a root problem, not a superficial one.
yes.
That yes, which portion is which. Even we could have admitted the appeal on the ground that the court itself should have directed a local investigation. It can be exercised so moto also.
Yes,
That would be a substantial question. But in view of in the teeth of your deeds, we are at a loss to understand. I mean, suppose we admit the second appeal, at the end of the day, what happens? I mean, on the basis of these deeds, the deeds do not specify which portion has been given to you.
Yes, that is true. That is the concurrent finding of both the courts. My lord, my prayers
Your
are
proper suit should have been, Mr. Bhattacharya, your proper. Initially, we were also stunned because declaration is granted, this is not given.
yes.
But then we find the substance, and your suit should have been. We need not advise you, you know better, Mr. Bhattacharya, but you should have sought for a partition with the co-owners and go for that with this declared decree.
True, my lord. Yes,
That would be a remedy. I mean,
because in my suit, my lord, the plaint was amended. First prayer is for a decree of declaring plaintiff's absolute right, title and interest of the suit property. B, for a declaration that the plaintiff has acquired valid right, title, interest in the suit property by virtue of deed of purchase purchase. Then, my lord, for declaration that the defendant Mayarani Sharma has absolute right, title, interest and possession over 16.5 decimal of land through the deed of gift. Mayarani Sharma is my vendor, my lord.
vendor.
And last, my lord, prayer is for a decree of permanent injunction restraining the defendant number 1, 2 and 3 from disturbing the peaceful possession of the plaintiff, and a decree for recovery of khas possession of the suit property. My lord, these are my prayer.
No, we are not interfering, but we are adding a line. I mean, by way of advice, we cannot do it, but that may help you.
Yes,
because, otherwise, it will be a toothless decree.
Partition.
The present yes, we'll just say something as in an as veiled manner as possible. Because we cannot advise advocates.
Yes.
Or clients.
Yes.
But we cannot resist that in this case. The present second appeal has been preferred against the judgment of affirmance, which both the courts below have decreed the suit filed by the plaintiff appellants partially. The suit was filed for declaration of title of the plaintiff stroke appellant as well as for recovery of possession and permanent injunction. Next para, learned counsel for the appellant argues that since both the courts declared the title of the appellant on the strength of transferred title deeds, the consequential reliefs ought to have granted, ought to have been granted as well. Next para, Learned Counsel takes the court through the findings of both the trial court as well as the appellate court. For the next para, however, comma, we find from the judgments of both the courts that those cannot be faulted. Full stop. Although the declaration of title has been made on the strength of transfer deeds produced by the appellant in his favor, comma, from the deeds themselves, as well as the chain deeds leading to such title, comma, it is evident that no specific demarcation was made as to the subject matter of the transfer, comma, although clear right in respect of a particular measurement of land was transferred in favor of the appellant. Thus, comma, the decree of recovery of possession stroke permanent injunction, comma, even if granted, would be inexecutable ab initio. Full stop. It is well settled that no decree can be granted by a court which cannot be executed in law. Full stop. Next para. Although learned counsel for the appellant seeks to place reliance on Order 26, Rule 18, capital A of the Code of Civil Procedure, and argues that even at the execution stage, comma, a local investigation could be undertaken for the purpose of ascertaining the portion of the property belonging to the appellant, comma, such argument is misplaced, since the problem with the identity of the property lies at the very root and source of title of the plaintiff stroke appellant, that is the appellant's title deeds. To sub next para, from the said deeds, comma, it is not clear as to what exact specifically demarcated portion was vested in the appellant, comma, thus making it impossible for any commissioner to ascertain as to what would be the exact identity of the subject property. Full stop. In view of such foundational flaw in the identity of the property, comma, the same cannot be rectified even at the execution stage. Full stop. In fact, comma, we cannot resist the temptation of suggesting that probably a suit on the strength of the declaration given in favor of the appellant seeking partition, comma, impleading the other co-owners, might afford an appropriate remedy to the appellant. So be that as it may, it is for the appellant to choose the litigation which it initiates and not for the court to so advise. So next para, be that as it may, comma, in view of the above observations, this court is of the opinion that both the courts correctly observed that although title of the appellant could be declared, comma, the consequential reliefs could not be granted in favor of the appellant. Hence, comma, SAT 24 of 2025 is dismissed under Order 41 Rule 11 of the Code of Civil Procedure. Can 2 of 2026 is also disposed of consequentially, no arrest to cost. Thank you, sir.
Instead of dismissal, my lord has passed some observation disposed of.
No, how can I dispose of? How can we dispose of an order 41 under Order 41? Order 41 Rule 11 does not contemplate. That would be an adjudication on merits then.
Yes, yes. It goes to single.
That is the fun of Order 41 Rule 11. You cannot have a disposal, either dismissal or admission.
And if
Item
disposal,
number
then it goes to single bench.
Yes.
So grateful to your lordship.
And 8 is
Thank
mine.
Yes.
And my appeal, my lord.
Yes, Mr. Rai. Yes.
I've been told that, my lord, this is appearing for dismissal, my lord. I don't know, my lord. But the point is, my lord, on the last.
Appearing for?
My lord, that why it should not be dismissed, my lord. This is what has been stated, my lord. My lord, I believe on the last occasion, my lord, there was a problem with this matter, my lord, saying that it has been marked as a SMAT and should be a second appeal and not a second miscellaneous appeal. Now, my lord, this was
No,
done.
this arises out of. This arises out of what? Order 21?
21, Rule 100, my lord, appeal from that. My lord, I said.
Then it's a second. No, SMT is maintainable. Why not?
My lord, that is what we were told, my lord. That is why on the last.
We had filed only. The department made that it should be SMAT. So accordingly, we made it
FMAT, yes,
SMAT. after granted by this honorable court.
No. What are you challenging in the SMT? What are you challenging? What on order
I'm
passed in what?
challenging an order of an appeal from an order passed under Order 21, Rule 97 to 100.
So then it's a SMT. It should be, isn't it captioned as an SMT? Yes, rightly.
Yes, well, we were told that it was not correctly done, but I suppose, well, then if your lordship.
No. We inquired as to whether it was I don't remember. Probably we inquired as to what it was, whether it was arising out of Order 21 Rule 101. Initially, we were not apprised as to whether it was.
I'm
Then we
sorry.
looked into the papers and we saw that it was from Order 41. That
Order
is the
21.
only situation. We also commented that probably this is that matter. We commented that this is the only situation where there can be an SMT.
I'm grateful, man. I'm grateful, man.
So provided what you say, I mean, it
Well,
arises from a misappeal, right? Misappeal from Order 21.
Yes, definitely. man.
Yes, absolutely. Please make your argument, Mr. Rai.
Yes, Malad.
Yes.
Malad, kindly see, Malad. I have won in the trial court and then I've lost in the appeal court, Malad. Malad, the point which has been upheld.
You are a third party register.
Yes, Malad.
We hope you are a third party register.
Yes, Malad.
Within one matter, we found a judgment data filing an Order 2101. So that's why you're asking it now.
Not that bad.
Not that, very
Not that bad.
Not that bad. Yes. What is your point?
Malad, may I just take your lordship straight to the Malad, the case at
Appeal.
Malad. Yes. Malad, straight away comes to the order, Malad. In page 6, Malad, if your lordship kindly takes once, Malad. Malad, first point is that.
Page 6.
Yes, Malad. Page 6. The original.
Page 6 of the.
But the order, the impugned order, Malad.
Yes.
Malad, kindly see, Malad, the petitioner is me, Malad, Onit Shah, contends that she acquired the piece and parcel of land at Moja Sagan by virtue of registered deed and value of concession from one Pradeep Ghosh, who delivered peaceful vacant possession on the date of execution of the deed. So, Malad, I got it from Nipendra Chandra Bose and Pradeep Kumar Bose. Then, Malad, will kindly, Malad, kindly see, Malad, then the OP came, Malad, my prime contention is at page 7, Malad, that the decretal amount, the property which has been described, Malad, is not the property where I am, or rather, it is not the property which belongs to my learned friend's client. And I've shown there were orders passed in earlier collateral suits, Malad, where my title was upheld. So, Malad, the point was, Malad, the point which we are arguing before Lordship, the second appeal point, Malad, is, Malad, whether, Malad, kindly comes to just gives you a moment, Malad. Yes, Malad. Malad, kindly comes to the point of, Malad.
Point judgment is there. Provision judgment court kore jay. Bhabe je ko bhalo judgment hoche.
Malad, kindly sees at page 18. Page 18 onwards, Malad.
Page 18 onwards is judgments and provisions of law and all these things.
Even though the document of the opposite party number 1, Malad, have you got that, the first paragraph, Malad?
First paragraph, even though, yes.
Even
document.
Document of the opposite party also suffers from same irregularity of Section 21 Registration Act, but the competent court, after considering the evidentiary value, was pleased to declare her title in TS 51 of 2003. And that's an earlier suit. Now, Malad, what
opposite party means who? Who is the opposite party?
Malad, I'll be the opposite party.
The decree holder?
No, here
you are the judgment register.
Malad, I am the third party, Malad, registered owner.
Okay, so you are the judgment register, you are the applicant.
Malad, this is the appeal, Malad. I was the
petitioner. You got a favorable order in the executive court?
Yes, Malad.
Oh, acha.
That is why, Malad. This is the appeal from the other side's appeal, Malad.
Right, yes.
Just therefore, Malad, Malad, kindly sees, Malad, a point of res judicata had been taken, Malad, which the learned judge has said that res judicata will not be applicable, Malad. Malad, kindly straight away, Malad, I'll just take your lordship to the concerned place, Malad. Yes, Malad. Kindly comes to page 38, page 23, Malad.
Yes, we are there, 23.
Just above that, Malad, section, Malad, 22 end. Section 11 of CPC lays down that no court shall try any suit or issue in which the matter directly and substantially issue has been directly and substantially in issue in a former suit. Same parties have been, Malad, this is Then can say rule is based on public policy. In other words, there must be an end to litigation. Doctrine of res judicata and principle of law established to be adapted to determine the question whether or not a matter is directly and substantially an issue in the former suit. To which the learned trial court failed to discuss the same while dealing with issue number 1, the maintaining of the same missed case, when the appellant party brought forward the certified copy of OC suit number 62 of 1977 and certified copy of OC appeal in the form of exhibit E and F. By virtue of section 11, by virtue of principle of res judicata, the application so filed by the respondent petitioner, Anita Naha, is completely barred too. Now, Malat kindly considers this point was never before the trial court. This point was taken here. So, Malat, therefore, Malat, I had raised the question, Malat, if you kindly sees my question. Malat, that is at ground 1, Malat. Malat, a commissioner's report.
No, give us the facts in a nutshell. Mr. Give us the facts in a nutshell. Just
the fact.
How did the trial court? Yes.
Malat, if your lordship kindly come. Malat, kindly comes to page 10.
Let us come to the trial court. I think that will be better.
That is where I am, Malat. Page 10 of the judgment, findings of the trial court.
Pagination is, we don't find any pagination in the trial court. Oh, the photocopies have effectively effaced those.
I'm so sorry.
No page numbering. What is the issue number? Give us the issue number. If you give us the issue number, we'll get the page. Appeal court na trial court bolche to.
Malat wants a trial court judgment.
Trial court, we have got the trial court judgment.
No, I'm on the.
You don't find any pagination. No. Let us see the trial court judgment first. We'll proceed with that. The appeal court says precious nothing. Only section 11.
Yes, Malat. Trial court, Malat, page number.
Are you finding page numbers in the trial court?
I'm also. No, but I'm also not getting.
No, it's not there. That's why you cannot find. Let us see whatever. Give us 5 minutes. I will just.
Sorry, Malat.
You said that the decretal land is different from your land.
That I said also. Yes, I did say. But that I'm not saying, Malat. What I'm saying, on the same land, Malat, it was in a commissioner's report, it was found that it is my land. There's a commissioner's report which was not given effect to. And also, Malat, there was a finding in another earlier suit to which, Malat, res judicata has been applied in this appeal, saying that it's a question of res judicata where, Malat, the finding was not in respect of the plaintiff. And I was not a party to that suit at all. So, the question is, res judicata only applies in cases of, Malat, identical issues arising out of the identical parties. It was between the plaintiff and another person, Malat.
Another person is, you're not claiming to any of those persons?
No, I'm not.
So how does that become German, that previous suit?
Because
how is that suit German?
The appeal court holds that since there is a finding that property was negated against the person who challenged the title of the plaintiff, therefore I cannot have title. It's a question of res judicata.
The present degree holder.
Yes.
I mean, the present degree holder got a degree in that suit against someone else.
Yes, Malat. So I cannot be
very well.
I'm not a party there.
Understood. But how did that executing court give you pass a deemed degree in your favor? Let us see that.
Yes, Malat.
Your title was held in this property or what?
Yes, Malat, in this property.
Achha.
Malat, kindly gives me one day, Malat, may I just get the pagination corrected? But I'm also not finding it a bit difficult, Malat.
No. How can you correct it? The certified copy does not contain
it. I will try and, Malat, get it in some way so that I can identify that with your lordship's brief, Malat.
No, need not. We are just doing it right now.
Okay,
we're trying to identify if there is any flaw in your case. This second miscellaneous appeal will be heard on the following substantial questions of law. 1. Whether the learned first appellate court substantially erred in law in holding that the appellant's claim was barred by the principle of res judicata, which objection was raised for the first time before the appellate court, and being a mixed question, could not have been could not have been considered by the first appellate court, comma, since it was not taken before the executing court. Full stop. 2, whether, comma, in view of the appellant not being a party to the previous suit, comma, on the strength of which the first appellate court held that the principle of res judicata applies, comma, the principles of section 11 of the Code of Civil Procedure are at all attracted to the present case. 3, whether the impugned judgment is a proper judgment of reversal in view of the learned first appellate court having not adverted to on merits on all the findings of the executing court. Yes, any interim prayer, Mr. Rai?
And I was wanting a stay, my lord, of this, but I don't know.
Acha, stay of operation means then the executing court revives. Very well.
Yes, but it does. It does revive, my lord.
Very well. There shall be stay of operation of the impugned judgment and degree till disposal of Can 1 of 2026. Full stop. The Can 1 টা এটা কি? না? Can 1 টা কি এটা?
Can one stay petition.
এটা Can 1 এখানে লাগানো কম্পিউটার ফরম্যাটে কি?
Your Lordship, Can 1 was filed for restoration because it was dismissed for default. That Your Lordship
there is no
allowed on the
stay
last
application.
week.
Then there is no
Your
stay
Lordship,
application.
No stay at the moment.
Very well, very well. ওইটা কেটে দিন তাহলে ওই স্টেটা তার বদলে the appellant shall put in postal costs and requisite for service of notice of the appeal on the respondent within a fortnight from date. The trial court record shall be brought by special messenger at the cost of the appellant, also to be deposited within a fortnight. There the appellant shall prepare and file the requisite number of informal paper books without comparing with the records within 6 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Liberty to the parties to mention the appeal for enlistment as and when the same is ready for hearing.
Very
Thank you.
good. Very good.
Thank you. Thank you. Next.
Item number 9.
Shiv, I beg your pardon. Inadvertently, the appeal is filed in the wrong format.
Wrong?
Wrong format. The entire pleadings has been annexed in the appeal.
Oh, acha. Memo you have not filed a memo?
The memo of appeal is filed, but along with the trial court's record.
No.
as well as the
Memo.
pleadings.
Why? Memo contains the judgment of both the courts. There is a report of the stamp reporter.
There is no
Report on
report
this
in this
particular-
regard, but there is a report with regard to the impugned judgment and order. That is 30th of July 2025, and the impugned challenged order is the same of the learned appellate court's order. 30th
Report
of
on
July.
this part could not be furnished as the date of application of the certified copy of the impugner appears to be wrong.
Firstly, the trial court's judgment is annexed, and thereafter the appellate court's order is annexed. The appellate court's order from the, your lordship can find the page from page number 20, internal page number 20.
It was a common application for certified copy. Same bunch. When was the appellate court judgment passed?
That is
It was
30th of July.
30th of July. 30th of July. No, but no. Could not have been. Application for certified copy was May 14, 2025. Either you file a fresh certified copy or it has to be sent down because the front page is missing of the certified copy application. If the appellate court judgment was of 30th of July 2025, how could you apply for certified copy in May, 2 months back?
The,
Cover page is missing in the certified copy application.
and
It
the-
transpires from the stamp reporter's report that the cover page of the certified copy of the appellate court's judgment is missing, comma, due to which the limitation period could not be calculated. So moreover, comma, no valuation statement has been mentioned in the memorandum of appeal. Full stop. Insofar as the second defect is concerned, comma, the learned advocate on record for the appellant is granted liberty to insert the valuation statement in the memorandum of appeal in both the judges' copies during the course of the day. By tomorrow. Full stop, next para. Insofar as the other defect is concerned, comma, the appellant is granted leave to file a fresh certified copy of the appeal court's judgment within 4 weeks from date. Full stop, let the matter be listed before the next circuit.
One more indulgence with regard to the filing number of this appeal.
What is
because
that?
the case arises out of from the appellate order of the learned trial appellate court. Appellate court's judgment is impugned.
Injunction order.
The remand back of the suit.
So rightly FMAT.
I think that would be SMAT.
No, that will be
The
FMAT.
first appeal has been preferred by the plaintiff.
No.
Sorry.
Because this is the we're telling you the distinction. Because FMAT, because the first order was passed by the appellate court. Remand is an order. Trial court passed a decree. First time an order was passed by the appellate court. Therefore, this is the first appeal which is being preferred against that order. The previous appeal was preferred against a decree. So it's a first miscellaneous appeal because this is the first time an order is being challenged. But in case of Order 21 Rule 101, the previous matter, the first court's judgment is a deemed decree. Executing court's decree is a deemed decree under Order 21 Rules 97 to 101. Therefore, the first appeal was preferred. The first miscellaneous appeal was against a deemed decree. Therefore, this is the second time a decree is being challenged. So, second miscellaneous appeal.
I thought I was under impression that the first miscellaneous appeal against the first order.
Next.
I'm grateful.
Item number 10.
Yes. Mr. Ghosh, you are appearing?
Yes, Millard.
Yes.
This for admission, Millard. Millard, what has happened here, Millard, is with this appellant, with X, this appellant had a suit. X filed the suit, we were the defendants. Now, that ended up in a compromise. Before the compromise agreement was executed, the suit property was transferred to a certain individual.
By X?
By X. XS, there were 3 individuals. They had transferred it to a certain individual. Now, once the
they actually became ex-owners.
Ex-owners. So when the compromise degree was arrived at, a decree was passed on the basis of that compromise agreement.
Oh, that is vitiated because they did not have title on that day.
They did not have title on that.
Yes.
Second, Millard, the compromise did not materialize. An application was subsequently taken out to set aside that compromise decree. That application is still pending in that earlier suit.
You yourself filed that application?
Yes.
On these grounds?
On this ground. That the amount which was agreed upon was never paid. Now, Millard, subsequently, when these persons to whom this property was earlier transferred prior to execution of the compromise agreement, all of a sudden appeared in the suit property and started infringing my rights. The second suit came in, which is from which this judgment arises. There, Millard, the trial court as well as the appellate court, subject to correction, Millard, misdirected itself in Millard dismissing the suit. Both the trial court as well as the appellate court dismissing the suit on the ground that I am stopped from filing this suit.
Stopped?
Stopped. Now, Millard, the application which was preferred, both caption and substance was on res judicata. Now, Millard, there are conflicting views whether this will act as a res judicata or not, the earlier suit, which ended up in a compromise. And Millard, secondly, probably, Millard, on the principle.
So this is an Order 7 Rule 11 has been allowed or what?
No, Millard.
Regular suit dismissed?
Regular suit by framing a preliminary issue.
Oh.
Now, Millard,
why stopped?
It's the court's third case. Their application was that the suit is barred by res judicata. The court brought in the principles of estoppel and said that even though res judicata in strict sense is not applicable, the suit is barred by the principles of estoppel.
No, that's because of the compromise probably.
That's yes, on the pretext of
but
compromise.
If a challenge is
even then, Millard,
pending,
estoppel probably cannot be a preliminary issue. It's a mixed question of law and facts.
No, but you address the issue. After that, you cannot take this on. It can be framed as a preliminary issue.
It can be.
As the first issue, you are right. Technically, you are right.
Yes.
Order 14 Rule 2 does not come in as far as this because it has to be a pure question of law.
Correct.
But it has been framed and decided. You argued. Both of you argued.
That's right. That's right.
So why shouldn't res judicata apply? As of today, the compromise decree still stands.
it still stands and application is pending for setting it aside.
Till it is set aside.
And admittedly, Millard, the amount has not been paid. Admittedly, amount has not been paid, and the deed of conveyance on the strength of which.
Have you annexed that compromise, the terms of compromise
Millard,
anywhere?
it's a change brief, Millard. That deed
Do you have a copy of that compromise?
not right now, Millard. Can I come back by a supplementary affidavit if Millard permits me? We can do it tomorrow. Okay, proceed.
Lordship, I have.
You are for the other side, caveator. Can you just hand up a copy?
Lordship, I have one copy with my.
But we are putting you on caveat that on the basis of that we may admit the appeal also, if you are satisfied. So now decide whether you will hand over. No, hand over for the assistance of the court. Don't be shy, hand it over.
He is always very innocent.
Compromise. Interesting question.
You are getting very interesting cases, Mr. Ghosh. Or you are making those cases interesting, maybe. We don't know.
Lordship, the setting aside of the compromise was filed subsequent to the filing of the suit.
But still it's pending. Filing of the suit, not before the decision of the suit. That's the difficulty. Your difficulty, not our difficulty. No, the compromise decree otherwise would be binding.
Lordship,
We
there
are
was-
at one with,
there
we are
was no
against.
question of consideration in that compromise decree.
That's why you are looking into this. That's what we are looking into.
ওই চিঠিগুলো দাও না, টাকা দেননি যে, টাকা দেননি, চিঠিগুলো কোথায়? There were more than one compromise agreements. The last one on which the court acted upon was of 21st December 2020. ওটাই দিয়েছিস?
যেটা কোর্টে ফাইল হয়েছে সেটা দিয়েছি।
আমার একটা কথা বলি,
আমার কাছে নাই, থাকলে তো দিত।
compromise deedটা কোথায়? Compromise deedটা।
Out of court deed তো?
হ্যাঁ,
You are the plaintiff there or defendant?
defendant. ওরা সুট ফাইল করেছিল তো?
না।
হুম?
আমার তো করে দিন।
প্রথম অরিজিনাল সুটটা। কম্প্রোমাইজ ডিডটা এখন লাস্টেরটা যেটাতে কোর্টে ফাইল হয়েছিল, আমি তো বারবার বলছি ওই ডিডটার কপিটা দেখান।
Is there any dispute regarding exes having transferred the property previously, prior to that? The dispute raised by them, the present, they have disputed that it was transferred by exes.
হ্যাঁ, yes, there was a dispute.
How was that decided by the trial court? Trial court held that in your case, that it was not transferred. Let us see the influence.
Subject to correction, Millard, there is no observation to that effect.
Just check up. It's a judgment of affirmance, both the courts.
Yes. কম্প্রোমাইজ দিকটা থাকে লাস্ট সিপিসি বইটা কোথায়? এটাতে আছে তো।
Will admit the appeal. Not on the question of consideration. The present appeal will be heard on the following substantial questions of law. One, whether both the courts below failed to take into consideration the legal effect of the explanation to Order 23, Rule 3 of the Code of Civil Procedure, and coming to the conclusion that the current suit is barred by res judicata stroke estoppel in the teeth of the pending challenge to the agreement for compromise, which was the very foundation of the earlier compromise decree, on the ground that such agreement is void or voidable. Next para, the next question. Whether both the courts below substantially erred in law in dismissing the present suit on the ground of estoppel stroke res judicata without even incidentally deciding as to whether the agreement on which the earlier compromise decree was premised was void stroke voidable, and consequentially whether the same was binding to attract the principles of Section 11 of the Code of Civil Procedure. Third, whether the learned First Appellate Court substantially erred in law in coming to the conclusion that the suit is barred by estoppel, in view of the earlier agreement between the parties having allegedly culminated in a purported decree, therefore obviating the applicability of estoppel and bringing in the concept of res judicata. Third ground is the worst ground, but since you have taken very well. Any interim application is there?
The stay application.
Your suit has been dismissed.
Yes. So
there is no scope of stay. We'll just dispose of the stay, and since you are appearing for only one respondent.
I'm appearing for the one.
One respondent. Very well.
Only one respondent.
Only one respondent.
Very well. In view of both the courts having dismissed the suit of the plaintiff stroke appellant by the impugned judgments and decrees, there is no scope of grant of stay. You have asked for injunction also.
Injunction, my lord, I'll just.
So direct both parties maintain status quo?
Yes, my lord.
No one grant.
I'm not appearing. I'll just associate the court with that document.
Injunction answer.
No, we'll have to pass an order of injunction since you have admitted the appeal. There's a prima facie case made out. So if you want, we can keep the injunction application pending if you want to use an affidavit in opposition. But that will delay your the appeal. I mean.
So at least an order of status quo will suffice.
No, if he wants to use an affidavit, if he's embarrassed because he's led, you are led by somebody. So we'll keep the injunction application pending.
Grateful.
But who is leading you?
Kushal Chatterjee. Mr. Kushal Chatterjee.
Calcutta. He would have said that let it be disposed of. Anyway, since the respondent wishes to
till that time at least
yes, that will go. That's what we said, that it will delay the matter for them. wishes to use an affidavit in opposition to the injunction application, comma, the respondent is directed to file such opposition within
6 weeks.
within 4 weeks from date, full stop. Reply, if any, shall be filed within a fortnight.
That the copy which has been served upon us is illegible, Lordship.
I'll serve after. I'll serve.
Without reply, if any, shall be reply thereto, if any, shall be filed within a fortnight thereafter. Full stop. Liberty to the parties to mention the injunction application before the appropriate learned single judge having determination after the above timeline of filing of affidavits is over. Full stop. The parties shall maintain status quo as regards nature, character, and possession, as well as possession in respect of the suit property, as well as shall remain restrained from dealing with the
Raising any further construction.
nature, character covers that.
Let's just specify it.
And as well as shall remain restrained from making any construction on the any construction stroke further construction on the suit property, and or selling, transferring, encumbering, and on alienating the same in favor of third parties till disposal of Can 1 of 2026. Yes, thank you. Arakta line at in view of the appearance of the respondent through the respondent's advocate, comma, service of notice of the appeal on the respondent is dispensed with. Full stop. The trial court record shall be brought by special messenger at the cost of the appellant to be deposited within a fortnight from date. The appellant shall prepare and file the requisite number of informal paper books without comparing with the records within 6 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appeal. Those directions were passing. Doctor.
Item number 11.
Lordship, if that document could be provided.
Oh, document. Please take it. You can annex it to your if you want. Your choice. Yes, who is appearing for 11?
I am for doing
Respondent. 11.
Lord, please allow me to appear virtually in the matter.
Yes, Mr. Mujumdar, you are appearing. Yes.
My lord, I am for the appeal, my lord.
Yes, what is the matter?
My lord, it is an appeal against an preliminary decree passed in a partition suit.
So we'll pass the usual order, Mr. Mujumdar, that final degree proceedings will go on, but no final degree will be drawn up.
My lord, in that case, may I please indicate to your lordship there is a delay application pending that needs to be controlled.
What is the delay, Mr. Mujumdar?
Lordship, there is a delay of total 1119 days.
1119.
My lord, I do not know what is the
On what
report of the
ground?
office. That is the calculation given by me, but I guess the office has counted it around 700 something days.
So whatever
It is, my lord, 700,
1100.
1100. The thing is this, after the preliminary decree was passed, because the parties are brothers and sisters, they tried to negotiate among themselves, and it is, my lord, will
No negotiation.
very well know that.
You
there
like
is
to
also-
use a opposition?
My lord?
Opposition, if you like 2 weeks, then you otherwise these go uncontroverted.
Lordship, I'll use the opposition.
Mr. Mujumdar, they are opposing. He has instruction to oppose. So let them file an opposition.
Mr. Mittal could have told it last day on, my lord.
No, he decided suddenly when he saw that it would go. The
He
realization
saw the-
came late. So that delay is condoned. The realization delay. His
My lord,
realization.
my lord, it is a circumstantial prompt.
Now, anyway, since the respondent seeks to use an affidavit in opposition to the condonation application, the respondent is directed to file his affidavit in opposition to Can 1 of 2025 within a fortnight. Do that within a fortnight from date. Reply, if any, shall be filed within a week thereafter. Let the matter be listed under the same heading before the appropriate division bench of the next circuit.
Obliged, my
2
lord.
weeks, 1 week, Mr. Mujumdar. Thank you. Yes.
Obliged.
Next.
Much obliged, Lordship.
Thank
Item
you.
number 12.
Not complete. Very well. Learned counsel for the appellant submits that service has not yet been completed. So accordingly, let the matter stand adjourned till the next circuit.
Item number 13.
Yes, what is the matter? Within time. Why were you not present? Or whoever was there? What is the ground for the absence? Use the microphone, ma'am. It's not a matter of course. You have to mention some ground. Why you were absent? Not a single sentence as to why he was not there. Not a single sentence. Learned trial court failed to understand, etc., etc. Grounds of appeal. Which paragraph, Mr. Ganguly?
This is not my case, but I'm assisting.
Find out a single sentence. No, actuality we are not interested. We are interested in the averments. বলেছে?
Para 2.
Is this a good ground? Order 17?
No.
In view of sufficient explanation for the absence of the appellant on the relevant date having been made out, can one of the... Oh, the other side was there when the... না এর আগে একটা তার আগে একটা করে দাও since comma on the date when the appeal was dismissed for default comma none appeared for either of the parties comma by applying the principle of order 9 rule 4 read with section 107 of the code of civil procedure comma the restoration application is taken up ex parte. Who's the next para? On a perusal of the application we find sufficient explanation for the absence of the learned advocate for the appellant on the relevant date having been made out. Accordingly, can 1 of 2026 is allowed, thereby recalling the order dated April 21, 2026 and restoring FAT 2 of 2026 to its original file and number. Was there an interim order? Are you sure? Interim orders, comma, if any subsisting on the relevant date? No interim order. তাহলে পরেরটা দেওয়ার দরকার নেই. No address to cost.
Since the order which has been challenged, that collusion ground was not mentioned in the divorce petition, and without giving an opportunity, it was just dismissed.
So have you got an interim application in connection to the appeal? So we are passing the usual direction then, put in the special. Was there any direction for? No, keep the affidavit with you. There was a direction for service. Keep it with you. এটা ছিল
বলতে হবে না নিজের
although there was an order by the Honorable Chief Justice that issue notice and etc. We are putting in the
Primitive services here.
no, not regarding service of this. Issue usual notice of the appeal. We are directing to put in special message. The appellant shall put in postal costs and due requisite for service of notice of the appeal on the respondent within a week from date. The trial court record shall be brought by this appeal is against what? The trial court record shall be called for by special messenger at the cost of the appellant, also to be deposited within a week. The appellant shall prepare and file the requisite number of paper books within 8 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant, liberty to the parties to mention the appeal for enlistment as and when the same is ready for hearing.
Can application that is the sub.
Keep it with you. There are reasons. Yes. We have recorded in an order that no service is necessary because by applying order 9 rule 4. And without a direction of court, you cannot serve. If you serve, if they appear, fine. If they don't appear, it's not good service because it is a substitute for rule being issued. The Appellate side rules still say we have to issue rules. We have substituted rule by direction of service. Unless we direct, no rule can be issued. By that logic, no service is valid. If they appear by appearance, we voluntarily appear. Getting that, if they appear, we take it as appearance. But otherwise, it's not a valid service. Need not. Yes.
Item number 14.
Actually, there was a direction to serve upon the learned counsel appealing for the.
You start with that because
Sure, I tried, but he refused to take this as because their client no more with them.
then you have to directly serve.
So then there may be a direction to serve.
This is
upon
a
the
section 5.
Section 5 application.
Learned counsel or restoration.
Restoration. I beg your pardon, restoration.
Learned counsel for the appellant submits that despite attempt to serve on the learned advocate appearing for the respondents, such service was refused on the ground that the respondents have taken the brief from the said learned advocate. Accordingly, we direct the appellant to serve copies of Can 2 of 2026 directly on the respondents, indicating that the application shall be listed before the next circuit. An affidavit of service shall be filed to that effect on the returnable date.
I'm grateful. My lord.
Thanks. Next.
Item number 15.
I am for the appealant. Am I audible, my lord? Am I audible, my lord?
Yes.
Yes.
Yes, Mr. Rai. Your
Yes, I'm sorry.
cough preceded you.
I mean now.
Your cough preceded you.
Yes, I have.
Yes.
No, no. Well, I am for the appellants.
Yes, Mr. Rai. What is the matter?
I am for the appellants. Is this shoot
Is
for
a pal
party?
for the other side or
Yes, pal is other
One?
side.
you're for the others?
Respondent number 3, defendant number 4.
1 and 3 are different. Very well. Mr. Rai, what is the matter?
It's a shoot for partition, and I have challenged the preliminary decree. My lord, the case of the appellants before lordships are the predecessors of the original defendant number 1. This is namely Vishwanath Ghosh. They have been substituted.
So what about service on the others? What about service on the others? 1 and 3 are appearing. 1 and 4 are appearing.
My lord, 1 and 3 are the Baki service.
1 and 4 are appearing. You are 4.
Respondent 3.
Respondent 3. 1 and 3 are appearing. Yes.
1 is my others service.
1 Mr. Pal is appearing. 3 Ms. Hanovis already appeared on the last occasion.
2 is not appearing.
2 is not appearing. There are 3 total.
No, I'll say my lord.
You are for
My lord,
2 and 4. What about service on 2 and 4?
My lord, Viva for the response number, defendant number 3. Falguni is for Miss.
It arises from a partition suit, Mr. Rai. You have to serve all.
No,
Partition suit all are on the footing of a plaintiff.
I serve all, my lord. I serve all. And then,
What is the affidavit of service?
this is, I'm sorry, my lord, that is brought in my.
You can see the affidavit of service in your hand.
Yes. Sorry, my lord. This is a difficulty. Junior has given me.
No, you have to file that for the records. Come back whenever, because if all appear to be no difficulty, but tomorrow can you do it?
Yes, sir. I'll send from here, my lord. Tomorrow I'll do.
Very well. Since
My lord, I undertake. I'll do it, my lord. I have served all.
No, do it. Definitely will. Since no affidavit of service is filed yet, let the matter stand adjourned for the day. Next.
Sorry, my lord. I kindly apologize, my lord.
No difficulty. No, why should you? Yes.
My lord, this is my problem. Going Siliguri and Calcutta both, I can't manage this.
Item number 16.
What is the defect?
It was that the appellants were not in the court below.
What?
And there was a dilemma. I have filed an application for
2376 days.
there are reasons for that.
So, was there any direction for service? Serve and come back. What?
Grounds to leave to refer the appeal. That can be.
Oh, leave is also sought. You are not parties.
My father was a party. After the decree was passed, he expired.
That might be one of the grounds in the section 5 was.
Because he has put an application on under 9-13. That was also disputed due to his death.
He died after the passing of the impute degree. Since the father of the appellant was a party to the suit from which the present appeal arises, ওটা plural হবে, appellants, was a party to the suit from which the present appeal arises, comma, and met his demise after passing of the impugned decree and before filing of the present appeal, comma, evidently, comma, the appellants have a direct interest in the outcome of the LIS, accordingly, can 1 of 2026 is allowed, comma, thereby granting leave to the appellants to prefer FAT 13 of 2026. No order as to cost. The appellants shall serve copies of Can 2 of 2026 on the respondents, indicating that the matter shall be listed before the appropriate bench in the next circuit, comma, when an affidavit of service to that effect shall be filed by the appellants.
Item number 17.
Please use the microphone. Yes.
I am for the appellant.
Appellants, yes.
Bring for next cycle, Lordship.
Why?
Could not prepare paper book, Lordship.
Paper book?
Yes, Lordship. There is a direction for paper book, Lordship.
The trial court records have arrived probably.
Trial court record arrived,
Oh,
Lordship.
acha.
I filed
Very
the
good.
certified copy, application for certified.
On the prayer of
copy.
learned counsel for the appeal for the appellant.
Yes, Lord.
On the prayer of learned counsel for the appellant, comma, let the matter stand adjourned to the next second. Grateful. Thank you. Give your names, both you and Mr. Ghosh's junior also.
Item number 18.
None appears for the parties. You are appearing, Mr. Dhar? None appears for the appellant at the time of call. Let the matter stand adjourned till the next circuit. Please give your name for this. Give the item number also, sir.
Item number 19.
Madam, for the
Yes, after a long time. Yes.
so long.
What
The
is-
affidavits are there, my lord. This is, we have collected the certified copy of the execution case. And we have a stay application also.
No, this appeal is directed against what?
It's against the money suit, my lord. It's a claim.
If you grant stay, you have to put in the amount.
Sorry, my lord.
If you grant stay, you have to put in the amount.
My lord.
Was there any direction for service?
No, it was admitted on the last occasion. It was for service. We have already served the other side.
Was there
We have
any
said-
direction for service?
Sorry, my lord.
Did the court direct you to serve or of your own?
Yes,
use?
yes, the court directed to serve. And also for the formal paper book also. We have filed the requisite fees of.
So you did not move the stay application then?
No, my lord.
Supplementary affidavit, why?
This is the execution, the certified copy of the execution case and all.
But money suit, then we'll have to direct
No,
you
this
to
is actually,
deposit the
we have-
decretal
we have
amount.
Power Grid Corporation, my lord. What happened, my lord, regarding the,
Whatever you are, you have to deposit the entire decretal amount then as condition of stay. When grant a limited stay,
not, actually, we have challenged that order. 5 lakh was the order.
no, that's the norm in money
My
suits, so money appeals. The appellant shall serve copies of Can 1 of 2026 as well as the supplementary affidavit filed today in connection therewith on the respondent, comma, indicating that the application shall next be listed before the next circuit. An affidavit of service to that effect shall be filed on the returnable date. There shall be stay of the impugned judgment and decree dated December 8, 2025, passed by the learned civil judge, bracketed senior division, Alipurduar, in money suit number 01 of 2022, unconditionally for 4 weeks from date, subject to the deposit of the entire decretal amount within the said period with the learned registrar, comma, Jalpaiguri circuit, comma, the stay shall continue till the disposal of the application. Next para, in default of such payment, comma, the stay order shall stand automatically vacated after the expiry of 4 weeks from date. If and when such amount is deposited, comma, the registrar Jalpaiguri shall invest the said amount with any short-term interest-bearing policy stroke account with any nationalized bank stroke corporation, comma, which will be subject to the outcome of the appeal.
Grateful.
Thank you. Specially fixed হবে না।
Item number 20.
Next circuit. Specially fixed হবে না। Next circuit. Order record করতে হবে। Specially fixed ধরে হবে কি আর দুদিনের মধ্যে। তুই সরকারি you are appearing?
21.
Call.
Item number 21.
We are sorry we could not reach these matters. We have been waiting for long. Even some others also.
Lordship,
We don't know whether
I'm
we will be able
appearing
to fix this
virtually in
matter.
item number 20.
Yes.
I'm not
No
well
difficulty.
today, so I'm unable to attend the court. Can it be fixed tomorrow at the first, at the top? I just
Tomorrow
want
we won't be
1
able
hour.
to dispose of. We won't be able to dispose of. You will complete in 1 hour. It's not humanly possible for us to dispose of
Lordship, it's a very
within
easy
1 day
matter,
after
so
that.
Lordship can hear.
For you. Not for us. 1 hour easy matter.
Yes,
If a
Lordship,
matter
it's a
requires 1 hour of hearing, it will require at least 4 hours. At least 4 hours of our involvement in passing the judgment
That's true.
and research
that's
work.
true. Very well.
What is
very
the
well.
matter about, Ms. Sharkar?
It's about BSF personnel. It's claimed that he has killed someone, whereas he was present.
Oh, you are in 20. You are in 20. Mr. Sharkar, 20.
Item 20. Item 20.
Oh, acha. 20 no, 20 harding part. Cancel kore di. You will cancel the part. Learned
Lordship,
counsel.
item 20
Ota
actually
part
part by the only my part is
not
pending
actually.
here.
What is reflected from the records?
Yes, it is. It was partly hard. Only my part is.
আরে
there,
ফাইলটা দিন না
it's not-
আগেরটার। উফ, এত আপনাকে কিছু দেখতে হবে না। না কোন। No, there is no parted mark. An adjournment is sought by learned counsel for the. You are for the respondent in the matter, Mr. Sharkar.
I'm for the appellant.
For the appellant, let the matter stand adjourned till the next circuit. 21 call করুন। 21 years. Parted, quickly finish it.
Quickly. It will take time.
One day we will.
Tomorrow, at the top, my lord, can this matter be fixed, my lord? I have
Can be fixed, but we won't be able to finish it within a day. Friday we won't be. We will be sitting for very little.
And I will give a written notes of argument along with the judgments, my lord.
My matter.
Item number 24.
I am also ready with this matter.
No other matter.
Only.
We have only 2 days of circuit. And
24 on
I'll
injunction.
take-
Appeal,
I'll
my
take
lord,
only
dear
20
lordship,
minutes,
please
my lord.
admit and fix this matter today. Your lordship, this is the order of injunction.
1 minute. কি করবো? Let it be in the list tomorrow. If you can't finish in 15-20 minutes, then we'll cancel the quarter.
Same prayer.
And if
kindly
come
fix
prepared,
my matter.
21 কিছু অর্ডার রেকর্ড করতে হবে না কালকে এগুলো কালকে কিভাবে লিস্টটা সাজাবেন একটু জিজ্ঞেস করে নেবেন
24.
Kindly fix my matter also.
What?
23.
23 is criminal appeal.
Criminal appeal.
No, no further criminal.
I will only take 20 minutes.
This is
my
a
lord.
part matter. That's why you are here.
Am-
Previous one is a part.
If your lordship seats
24, my lord, if your lordship kindly consider.
No,
24, my lord.
23 no, 24 what is it?
Injunction, my lord. Against the order of injunction, this appeal has been filed, my lord. Each and every day, my lord, the huge.
The 24 injunction appeal will keep tomorrow.
Yes, my lord. Tomorrow, my lord. That is the prayer.
No urgency. I pray for the respondent. There is no urgency.
24 we are keeping tomorrow.
Yes, my lord. Grateful to you, lord.
Item number 25, my lord. Item number 25. May I please, lordship? Lordship, item number 25, my lord.
Oh, top, my lord. Top.
No, special it's already appearing specially fixed. So let this appear in the list. We are not passing any order. This will appear as specially fixed tomorrow. We'll decide tomorrow whether it can be decided.
My lord, for the item number.
Passing in order to.
My lord.
Whatever order it is appearing, it will appear because the order 41s are over today. The previous matters are over today.
My lord,
So those will remain in the list tomorrow.
My lord.
Up to tomorrow we will hear, but day after tomorrow probably we will be taking 2-3 matters.
one matter was mentioned yesterday for withdrawal.
Yes, it was mentioned to this morning also. A slip was given.
I tried to mention it, but I could not permit.
Oh, that is the matter.
Yes, Lord. Yesterday I have mentioned.
If it has been already mentioned, আসছে না কেন একটু খোঁজ নিন একটু withdrawal এর matter এতদিন ধরে অপেক্ষা করে দুটো matter হলো নি
My lord, item number 25, my lord. Item number 25, my lord. My lord,
no.
item number 25, 25 is, my lord.
Pardon? Single bench. Right to be mentioned and hand over. Yes.
Item number 1.
Lordship, there is only a small correction to be made in the order.
Yes.
It's Lordship, on the para 3 of this order, which was
Yes.
passed by your Lordship, it has been written as the unskilled Aya in a government hospital in Jalpaiguri. Your
Yes.
Lordship, it will be a private nursing home in Shiliguri.
Unskilled IR remains.
Yes, unskilled Aya remains.
In paragraph number 3 of the order dated June 12, 2026, comma, instead of the expression double inverted mode in a government hospital in Jalpaiguri, double inverted close, comma, the said phrase should be read as within double inverted in a private nursing home in Shiliguri, double inverted close, full stop. Let the order dated June 12, 2026 be deemed to stand corrected accordingly.
Gratefully.
Item number 2.
So for the respondent claimants.
Yes. Why to be mentioned?
Minister direction is required for paper book and all other things.
You already filed.
But copy not served.
Actually, you are not appearing in this.
Acha. You're for the respondent.
I'm for the respondent claimant.
You filed in court.
In the department, it's already here. 2 copies are there. That's all.
তাহলে পেপার বুকটা তাহলে নেমে যাবে, এটা নেমে যাবে, অর্ডারটা পাস হলে নেমে যাবে। Learned counsel for the respondent seeks directions for preparation of paper books. Full stop. However, learned counsel for the appellant stock insurance company points out that the appellant has already filed the requisite number of paper books. Full stop. Hence, liberty is granted to the learned advocate for the respondent to take a copy of the said paper book from the department. The liberty to the parties to mention the appeal for inclusion in the list before the next circuit. Thank you. The record will go down. You take from the. Thank you.
Item number 3.
Which section? My lord, in this matter, I am for the appellant claimant.
Your Lordship, yes. What do you want?
Insurance company in this, Your Lordship.
Paper book. I have prepared paper copies hard.
So what do you want now?
Paper book.
You're filing the paper book?
Yes.
The paper book filed by the learned advocate for the appellant today be kept on record. Full stop. Since the appeal is otherwise ready for hearing, comma, liberty to the parties to mention the same for inclusion in the list before the next circuit.
Your Lordship, there's one order is required in this, Your Lordship. If there's connecting matter to it, insurance company has also preferred an appeal. Both the matters has to be tagged together. Your Lordship, the number of that case.
What is the number? What is the number, Mr. Ganguly?
FMAT MV 89 of 2025. FMAT MV 89 of 2025.
29.
25, Your Lordship. 2025.
25.
89 of 2025.
89 of 2025. Let such and such be tagged with the present appeal for being heard together. Full stop. A copy of the memorandum of the same shall be circulated among the learned advocates for the other parties by the learned advocate for the appellant in the said appeal. In the meantime,
Deeply obliged, Your Lordship.
he'll circulate copies of the memorandum to you. Both of it. Thank you. Next.
Item number 4.
Lordship,
Yes.
in this matter, on 10th June, one order is passed. But kindly see the earlier orders, Lordship.
There were directions for preparation.
Yes, everything was there.
Those have
Actually,
been prepared.
they are delaying. Kindly see the earlier 2 orders.
On 10th day of the, you will learn court actually to pass an order for.
Who is for the appellant? You are for the appellant. Why didn't you file? One opportunity was given to you.
LCR was called for.
LCR has not yet arrived.
No. On
Learned counsel for the respondent submits that although directions for paper books and consequential other directions were passed due to order dated June 10, 2026, comma, previously the appellant had already been directed to prepare paper books which have not yet been filed. Push up. It is also pointed out that by an order dated March 27, 2026, comma, Another opportunity to file paper books was given to the appellant within 4 weeks therefrom. Push up next para, learned counsel for the appellant, however, submits that unless the notice of arrival of the trial court records is served on the learned advocate, the paper books cannot be prepared. Push up, accordingly, the office is directed to ensure that immediately upon arrival of the trial court records, if not already arrived, a notice of such arrival shall be served on the learned advocate for the appellant. Push up, the earlier directions and time limits for preparation of paper books shall remain in place. Thank you.
Item number 5.
Lordship,
yes,
I am for the respondent. This matter is of accident took place in the year 2001.
So what do you want now?
Early hearing.
The case was
Paper books are prepared.
no. The case was disposed in the year 2025. Incident was occurred in 1998. Case was filed 2001. Case has been disposed by the learned lower court in 2025. And thereafter, this appeal was filed, and this is the affidavit of the service.
Of what?
Service of the notice.
That we have received. That is where I am appeared. Lordship, in the memorandum,
The judgment was passed by the lower court in the 2025.
No, very good, but
Lordship, kindly see the paragraph.
trial
number.
records have not yet arrived.
No. Just a summons has been served upon the opposite party.
So direct the trial court records.
How it is dragged. Kindly see the paragraph number 19 and 20.
I am not dragging the case.
No, what will you do by knowing that? We will direct the paper books, the trial court
Lordship,
records to be filed.
We require hearing, earlier hearing.
Affidavit of service filed to be kept on record. Full learned counsel for the respondent submits that the appeal is pending since long. Full next para. Be that as it may, the trial court record shall be brought by special messenger in order to expedite the appeal. Full the costs of such special messengers shall be put in by the appellant within a fortnight from date. Full the appellant shall also prepare and file the requisite number of paper books within 6 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Stop. Liberty to the parties to mention the appeal for enlistment before the appropriate circuit as and when the same is ready for hearing.
Item number 6.
It appears from the office report dated June 16, 2026 that no special messenger cost has yet been deposited by the appellant as per the direction of this court dated January 3, 2025. Full stop. The time for deposit of special messenger cost is extended for a fortnight from date. Full stop. In default, the matter be listed under the heading Lozima for final orders before the next circuit.
Item number 7.
Appearing.
Yes, Lordship, I am with the appellant.
Special messenger cost you have not deposited.
I am not deposited, Lordship. Then
The time for filings on the prayer of the appellant, the time for filing depositing special messenger cost is extended for a week from date. In default, the matter be placed under the heading Lozima for final orders before the next circuit. You do it within, immediately do it.
Lordship.
Item number 8.
No special messenger cost has been deposited in terms of the direction dated March 25, 2026, as per the office report dated June 16, 2026. Full stop. The time for depositing such costs is extended for a fortnight from date. Stop. In default, the matter be placed in the list under the heading Lozima for final orders before the next circuit.
Item number 9.
Same order as per the direction dated March 18, 2026. Makishab Act. Office report date to act.
Item number 10.
My lord, for item number 10, I am appearing on behalf of the petitioner, my lord.
Why didn't you put in the special messenger cost?
We didn't, my lord.
No. You're asking me. The time
They have
for
only served
deposit.
a can upon us.
the time for depositing special messenger cost is extended, comma, on the prayer of the appellant, comma, for a week from date. Full stop. In default, list the matter under the heading lodging for final orders before the next circuit. Within 1 week, please deposit.
Grateful, my lord.
And otherwise, the appeal will be dismissed.
Item number 11.
My lord,
On, in item number 11, I am on behalf of the.
my lord, can I submit the paper book for this matter?
File it in the department.
In this case also, paper book is not yet,
No, special messenger cost is not.
not yet deposited.
ওই এটা এর আগেরটা যেটা হলো স্পেশাল মেসেজ কজ দেয়নি as per direction dated August 14 2025 office report same date.
Item number 12.
Appearing, no special messenger. On the prayer of the appellant, the time for filing, time for depositing special messenger cost is extended for a week from date. In default, list the matter under the heading lodging for final orders before the next circuit.
Item number 13.
None appears for the parties at the time of call. Full stop. Let the matter be placed before this bench. Acha na. None appears for at the time of call. Let the matter stand adjourned for the day. Amari content কিছু করার নেই।
Item number 14.
Same order. Same order.
Item number 15.
My lord, I'm praying for not today. Mr. Roy Mahashaya will be appearing in this matter. And he's
Then
possible committee.
after next circuit. An adjournment is sought on behalf of the petitioner. Let the matter stand adjourned till the next circuit.
Lordship.
Item number 16.
Yeah, I'm for the petitioner.
Yes. What is the matter?
Challenging the order of the Lana District Magistrate.
Is that matter that it will be taken up in the? It will be taken up tomorrow, today. No, not that matter. That matter was taken up yesterday.
Yesterday, last matter was taken up, but
This one,
due to
yes.
paucity of time.
Yes.
Lordship, the interim application, interlocutory application was filed in connection with the section 17 application before the DRT Siliguri, Lordship. The main challenge was that the order of the Lana District Magistrate absolutely bad because no satisfaction recorded and secured creditor was permitted to take physical possession with the assistance
But
of
you
the
can move before the appellate
Lordship,
tribunal.
I have filed interim application. When the matter was came up for hearing, bank filed their opposition on the same day and served copy to me. And without giving a single opportunity to peruse the same, Lordship, the hearing was concluded and order was passed. Absolute violation of natural justice, Lordship.
What is the date of the order? Order number
Lordship,
29.
page number 76. Lordship, heard the learned counsel of both the parties on IA such and before that, the learned counsel of the bank files objection and serves the copy to the learned counsel of the applicant, leaves the matter on 26 March for passing the order. I didn't even get a chance for peruse the opposition, and mostly, Lordship,
You are not heard on the next date. It was closed. Hearing was closed.
on that day hearing is concluded. An order was passed, judgment was passed on 26 March. And Lordship, the bank filed the opposition without annexing the copy of the affidavit 9 points affidavit, whereas my specific challenge was that the bank did not file any 9 points affidavit. And from the record of the district magistrate, Lordship, can you see page number 41 once? This is the order of the Lana District Magistrate, 8-line order, Lordship. nothing reference given that he has perused the 9 points affidavit or it is filed being satisfied, nothing. Whereas the authorized officer such and such applied before the district magistrate Uttar Dinajpur for taking possession of the secured asset and noted below as noted below under section 14 of the SARFAESI Act. Whereas the secured asset within the jurisdiction, whereas the secured creditor
in view of a prima facie palpable abuse of the process of court and violation of natural justice vitiating the impugned order, comma, the present application under Article 227 of the Constitution of India is entertained despite the availability of an alternative remedy by way of a challenge before the appellate tribunal, before the debts recovery appellate tribunal. First of next para, by the order dated March 12, 2026, comma, the tribunal, comma, while permitting the respondent bank to file an objection to the challenge preferred by the petitioner under section 17 of the SARFAESI Act, comma, recorded that a copy of the objection was served on learned counsel for the petitioner on the self-same date and time, but still concluded the hearing of the matter without granting any opportunity to the petitioner's counsel to address the averments made in the objection and or even to go through it. First up, consequentially, comma, by the order dated March 26, 2026, comma, the tribunal, comma, by relying on the opposition as well, comma, written objection as well, comma, disposed of the challenge against an order passed under section 14 within bracket 1 of the SARFAESI Act. First up, thus, comma, the said orders are palpably vitiated by violation of the principle of audio alteram partem. First up, next para, the learned advocate for the petitioner also raises a foundational question as to whether the order under section 14 of the SARFAESI Act passed by the district magistrate, comma, which was assailed before the tribunal, also suffers from patent lack of jurisdiction in view of the tribunal in view of the magistrate having failed to advert to the failed to record satisfaction regarding the mandatory parameters to be satisfied by the bank by way of a 9-point affidavit as required under the said provision. First up, next para, the divisional application shall be heard on the above questions and the other grounds taken in the application. First up, the petitioner shall serve copies of CO 1340 of 2026 on the respondents, indicating যেখানে respondents বলছি সব opposite party করে দিই, on the opposite parties, indicating that the matter shall next be listed for hearing before the next circuit when an affidavit of service to that effect shall be filed by the petitioners. Full stop. There shall be stay of operation of the impugned.
One more thing. To avoid this adjudication, Lordship, bank has taken physical possession on 4th of June during pendency of the civil division. Bank.
Then there is a scope of stay.
Kindly stay the lower court proceeding and maintain status quo.
There is a scope of another proceeding. What proceeding?
Lordship.
What proceeding?
The section 17 proceedings.
14 is only on no. 17 has been decided.
17 is pending. This is the IA. Impugned order on IA, Lord.
একটা জায়গায় রেকর্ড করি dispose of the section 17 proceeding under section 0. Dispose of section 17 interlocutory application in connection to section 17. যেখানে written objection, by considering the written objection, dispose of the proceeding to an interlocutory application. But your section 17 application, let it continue. Why should you stay that? We'll say that if the position has been taken, that will abide by the outcome of this revisional application. Next para, since the court is apprised that despite the pendency of the revisional application, comma, the bank has already taken possession
4th of June.
on of the subject of the secured asset on June 4, 2026, such taking over of possession shall abide by the outcome of the present revisional application. Furthermore, the opposite parties shall maintain status quo with regard to the said property till August 31, 2026, or until further order, whichever is earlier.
Grateful, man.
Thank you. Oh, sorry.
Grateful.
Item number 7.
Yes, Mr. Ghosh. Yes, yes. It was done on his ground.
Yes, sir.
Because he was not there. Yes.
Milord, arises out of Milord a preemption proceeding. Milord, on the learned Civil Judge Junior Division, Milord, was
You were the preemptee or the preemptor?
Milord, I was the opposite party purchaser. Milord, the learned Civil Judge Junior Division, Milord, held that the application is maintainable, allowed the application. Similarly, Milord, the first appellate court also, Milord, has upheld that decision.
You took a challenge to maintainability at the outset.
No, Milord. It's on merits. The challenge is, Milord, so far as Milord the applicant is concerned, there is no independent finding or inquiry by the court with regard to his status as a co-sharer. Now, there are materials on record to suggest that he has a house somewhere adjacent to the property, but the boundary of his land, as well as Milord, the land which is described in the application, Milord, is insufficiently described. And Milord, first time Milord, I see an application under Section 8 of with regard to a schedule of land without boundary. Milord, the proceeding is fundamentally flawed, Milord, subject to correction. Now, Milord, kindly first produces the application itself. Page 13, Milord, is the schedule of the subject land.
Yes.
Milord would find without any boundary. Now, Milord, the first test, the elementary test under Section 8, co-sharer, longest common boundary. And there is no inquiry to that effect. On the basis of oral evidence that he has a house in the eastern part of the property, the application has been allowed. And Milord, so far as the plot is concerned, it's a huge plot. There was no partition amongst the co-sharers of the plot also. That's on record. That there has been no partition so far as the plot is concerned.
Yeah, but then he remains a co-sharer.
Remains the co-sharer, but the boundary has to be ascertained.
So, but there is no competing co-sharer who has.
There was no competing co-sharer. Even then, Milord.
No, but the law is that if there is a competition, then
the longest common boundary.
But if there is only one applicant, then longest common boundary.
Even apart from that, Milord, what is the position of the subject property where the applicant's land is situated, whether he can claim that he can enforce a weak right of preemption, Milord, that has to be inquired properly.
No, but his title deed must have been produced to show that he is a co-sharer.
His title deed is produced, the boundary raises serious suspicion. I'll show your lordship.
If the same plot is mentioned, Mr. Ghosh, then even without the boundary, he remains a co-sharer. If it was contiguous owner, then I could have understood.
Milord, his boundary raises a doubt whether he has a land contiguous to my land according to his
contiguous is not his ground. His ground is co-sharership.
Co-sharership. Co-sharer and contiguous.
But it was allowed only on the ground of co-sharership.
Co-sharer and contiguous.
Both were
considered and it was allowed. On the basis that he is enjoying an adjacent.
But even if he wins only on co-sharer, then he gets a preemption, Mr. Ghosh.
Then he gets a right of preemption.
But if he has shown a title deed showing that this property here, he's the owner of this property even without a boundary, the same plot.
Milord, kindly seize his boundary once, Milord.
From his deed.
From his deed.
Yes.
At page 69.
What is the subject plot? The plot which is
161.
So he gets a right title in 161. দাগের শতকের 57 শতক মধ্যে লিঙ্ক চৌহদ্দি স্থিত 10 শতক.
Yes.
So it's within that plot. So he's a kosher of that plot.
Yes,
Established.
but the boundary doesn't match my boundary. I am nowhere around his land.
No, the subject property is 161.
Subject property is 161.
He is a kosher of 161. Mr.
He is kosher of 161. Secondly, Millard, it's on record, Millard, the written objection that there was a meeting held where everyone has notice of the transaction. And Millard, there is no specific denial of that.
What is the limitation? I've forgotten for kosherer.
Millard, 3 months from the date of
3 months from date of
3 months from the date of there, Millard, there is no fault. It's within limitation. I've checked. And the point of notice, Millard, it was a point taken in the written objection
notice
that he had
becomes irrelevant if it came within the 3 months. How is notice relevant?
Actually, my lord, what my knowledge is, they are trying to demonstrate there was a meeting where I was present.
Yes.
But that was specifically denied by Misal.
No, how would it make a difference? If you are present, you had notice.
No, my lord.
If you were present, you would have notice.
I have notice.
If you had notice, then even then you come within 3 months from that.
No, my lord. So far my case is concerned, no meeting was held.
Millard,
You're not getting up.
Millard, the point is that if he is present in the meeting, he has waived his right to purchase the land.
No, my lord. That is
Has
not,
to be conscious relinquishment of our right.
that is not.
That's
That
not
has to be
okay. That's
proved by
not
you.
that conscious relinquishment is
Nothing,
not borne
nothing,
out from
nothing.
the
The benefit of having assistance of good advocates is that they know where to stop. I'll record your submission at length. The present challenge has been preferred against an order whereby both the courts below have granted preemption to the opposite party preemptor on the ground of koshership as well as contiguous ownership. So next para, learned counsel appearing for the preemptee stroke petitioner submits that there is a foundational flaw in the impugned judgments inasmuch as no boundary of the subject property was provided in the schedule of the preemption application itself, comma, which raises a question as to the identity of the property. Full stop. More importantly, comma, it is contended that there is some discrepancy in the boundary of the plot purchased by the preemptee stroke opposite party, comma, as depicted in the title deed produced by the preemptee. Full stop. Next para, learned counsel contends that in the absence of consideration of whether the preemptor is the kosherer is a contiguous owner with the longest common boundary, comma, the courts below could not have granted preemption on the ground of contiguous ownership. Full stop. Next para, it is next argued by learned counsel for the petitioner that sufficient material was produced in the courts below to establish that the preemptor stroke opposite party was present in a meeting where there was a talk where there was an amicable discussion in respect of the subject property. Thus, it is submitted that the preemptor was stopped from subsequently resiling from such position arrived at in the meeting and seeking preemption. So next para, learned counsel for the preemptor stroke opposite party controverts the submissions of learned counsel for the petitioner and argues that it was never established that the preemptor was present in the concerned meeting. Full stop. Even otherwise, comma, it is submitted that sufficient materials were before the court to grant preemption. Full stop. Next para, for the time being, comma, even assuming that the petitioner could not produce the longest common boundary belonging to, the preemptor could not establish the longest, could not establish that he is a contiguous owner with the longest common boundary, comma, in the absence of any competing claim of preemption by any other contiguous owner, comma, the said issue loses relevance. Push up, even otherwise, comma, since preemption was granted also on the ground of co-sharership, comma, the preemptor, it would suffice if the preemptor could establish the same. Push up, next para, from the title deed of the preemptor, comma, as annexed, a photocopy of which is annexed to the present revisional application, comma, it is evident that irrespective of there being certain issues regarding the boundary, comma, fact remains that the preemptor purchased a portion of the subject plot, which is plot number 161. Full stop. The same logic applies to the schedule of the preemption application as well, comma, since the same, comma, despite not mentioning the boundaries of the plot specifically, comma, mentions that the relevant plot sought to be preempted is plot number 161. Push up, next para, thus, comma, the preemptor has established the foundational fact of being a co-sharer in respect of the subject plot being plot number 161, which was sufficient for grant of preemption on the ground of co-sharership under Section 8 of the West Bengal Land Reforms Act 1955. So next para, insofar as the other contention of the petitioner is concerned, comma, it is well settled that in order to constitute waiver, comma, there has to be a conscious relinquishment of a right by a particular party. Push up, in the present case, comma, there was no clear proof of such conscious relinquishment of the right to preempt on the part of the preemptor stroke opposite party. Push up, since the burden of such proof lay on the person asserting it, that is the preemptee stroke present revisionist petitioner, comma, in the absence of discharge of such burden, comma, it cannot be said that the petitioner lost his right to preempt, that the preemptor lost his right to preempt, even if it is taken for argument's sake that he was present in the meeting in question. Push up, in any event, comma, since the presence of the preemptor in the meeting is also a disputed question of fact, comma, it is beyond the pale of an application of a court sitting in superintending jurisdiction under Article 227 of the Constitution to reassess the evidence and enter into the merits of such mixed question. Push up, thus, comma, the revisional application fails. Accordingly, CO number 160 of 2025 is dismissed on contest against the preemptor stroke opposite party, thereby affirming the impugned judgment dated May 21, 2025, passed by the learned additional district judge Dinhata, Kuch Bihar, in miscellaneous appeal number 01 of 2024, thereby affirming the judgment and order dated December 15, 2023, passed by the learned civil judge junior division at Dinhata, in miscellaneous within bracket preemption bracket close case number 04 of 2010, no order as to cause urgent service. Sorry, Mr. Ghosh. Yes. Thank you. Next.
Item number 18.
In this camp 305, but mistake by clear did not annex death certificate.
So then supplementary affidavit should be. Death certificate must be there. So we put it in the next circuit.
Problem is that camp is pending, the extension petition is pending.
Unless the substitution is allowed now. On the prayer of learned counsel for the petitioner, comma, leave is granted to the learned advocate on record for the petitioner to file a supplementary affidavit annexing the death certificate of the deceased party for which substitution has been prayed. Push up, let the matter be listed in the next circuit. For such purpose. Thank you.
Item number 19.
Well, I am for the petition in this matter.
Yes. Yes, Mr. Sharkar.
Malad, yesterday, I handed over.
Yesterday they were not there, so today, no difficult. So you have filed the affidavit of service? Yes. Service was affected?
Yes, my lord. Yesterday, your lordship taken affected, my lord.
Have you checked up? They have received? Yes, item delivered. Yes.
My lord,
Please move the
wife
matter, Mr. Sarkar.
received, my lord.
Yes.
My lord, I filed a suit, my lord, for divorce, my lord, which is pending before the learned court, my lord, at Purulia.
Yes.
My lord, the wife also, my lord, filed a suit, matrimonial suit, my lord, for restitution of conjugal rights before the learned court at Tufanganj. My lord, before
Yes.
moving this, my lord, revisional application, my lord, wife has come before this honorable court for transferring the divorce suit from Purulia to Tufanganj. That is, my lord, CO 3994 of 2025.
That is not appearing today.
No, that was also, my lord, disposed of. My lord,
disposed
in
of?
this revisional application, yes, my lord.
Huh.
My lord,
How was
giving
it
me
disposed of?
right.
It was dismissed.
No, my lord, it was directed that the divorce suit which was filed by me in Purulia, that should be transferred to the district judge at Tufanganj.
Tufanganj, right.
And I have given the liberty, my lord, to, my lord, file an application to appear before the learned court at Tufanganj on virtual mode.
So what do you want now?
My lord, my prayer is similar to that effect, my lord, which has been passed by the Honorable Justice Shompadatta Pal, my lord. My lord, I could appear before the Tufanganj, my lord, virtual. That is my prayer at present. Because my divorce suit has been, my lord, already transferred, my lord, so I could not place before the lordship to transfer the, my lord, section
But here
9
you have asked
application
for a
from
reverse
Tufanganj.
transfer.
But I've asked
So
for
already
reverse
it has been
transfer
transferred
of the
from Purulia to Tufanganj. Why should I retransfer back?
No, in this revisional application, I prayed, my lord, that section 9 application, which has been filed by the Y before the learned judge as Tufanganj, that should be transferred
Yes.
to Purulia. My lord, this is my prayer in this, my lord, revisional application. But before
No,
that,
why
the
should
wife
it
has
be? It has already been transferred from Tufanganj to Purulia. Rather, Purulia to Tufanganj.
That is in respect
Oh,
of
acha, the other suit.
divorce suit. Yes, my lord.
Mr. Sarkar, the difficulty is your voice is getting cut off every time. So I can't hear any sentence. Where is the previous order? Which page? The previous order of transfer of your suit?
My lord, that is not annexed, my lord. It was subsequently, my lord, passed. My lord, 13th, my lord, January 2026, it was disposed of.
So unless you see that order, we are required to look at. So by that order, what was done? I mean, your divorce
Lord,
suit
my
was
divorce-
transferred from Purulia to Tufanganj.
Yes, my lord.
All right. And now you want.
My lord, in this revisional application, I only pray before your lordship. My lord, kindly give me liberty to, my lord, file an application for by appearing before the Tufanganj court, my lord, on virtual mode.
So you restrict your prayer to that?
Yes.
This was filed before the order was passed in the wife's suit. This was filed before that.
My lord, my suit was filed.
No, this application was filed prior to her order.
Yeah. Yes.
Oh, acha. Very well. So I'll record these facts and fair enough, Mr. Sarkar. It's a fair enough submission. The present application has been preferred. No, acha, very well. Your suit was for divorce, right? The present application has been preferred by the husband for transfer of a suit filed by the opposite party wife for restitution of conjugal rights from Tufanganj to Purulia. Full stop. Learned Counsel for the petitioner submits that the husband had filed a divorce suit against the opposite party at Purulia, which was the premise of filing the present transfer application. Full stop. However, it is fairly submitted by learned counsel that in the interregnum, the opposite party wife also took out an application for a reverse transfer of the husband's divorce suit from Purulia to Tufanganj, which has since been allowed. Full stop. In such view of the matter, the present prayer for transfer of the wife's suit from Tufanganj to Purulia has been rendered rather infructuous. Full stop. Thus, learned counsel for the petitioner now presses a limited prayer that the petitioner be permitted to apply before the appropriate court at Tufanganj, where both the suits are now pending, for appearing virtually. Full stop. Next para. In such view of the matter, CO 8 of 2026 is disposed of with liberty to the husband/petitioner to make an appropriate application before the court where the suits of the parties are pending in Tufanganj, for being permitted to appear virtually as far as possible, subject to availability of video conferencing facility in the said court. Full stop. If such an application is made, the learned trial judge shall pass an appropriate order on the same. There will be no orders to cause certain certificate copies. Thank you, Mr.
Grateful.
প্রথমে একটা করে দিয়ে affidavit of service filed to be kept on record despite service, none appears for the opposite. Thank you. Next.
Item number 20.
Order 26, Rule 9 was rejected.
You are the plaintiff.
I was the plaintiff.
Suit for
Millard, perpetual injunction and recovery of possession.
identity of the property in dispute.
Identity and property, even the defendants have disputed. In the written statement specifically stated, it requires to be demarcated.
Why refused?
Millard, tantamounts to fishing of evidence.
Yes, should be allowed.
My lord, it is the plaintiff filed suit in the year of 2020. My lord, after that, the amended petition was filed. It was allowed. After that, now they are pressing the order 26, Rule 9, my lord. My lord.
What is the stage of the suit?
My lord, it is the suit is the hearing.
No, hearing.
Yes. Issue frame.
Well, only issue has been framed.
Issue frame, my lord. My lord.
26/9, when will they file? Before filing of the plaint?
No, my lord.
When does a party file a 26/9 application? They file it early. I'll permit them to file a bit later.
My lord, kindly see the title. They did not claim any title declaration. My lord,
did not.
They did not pray any petition for the demarcation of the suit.
They have
My lord-
alleged that you have encroached upon a portion of the property because they have sought for recovery of possession after evicting you by removal of unauthorized tin fencing.
My
If
lord-
that allegation is made, it has to be seen whether it has been made, that tin fencing,
And the
and
plot
if
number.
so, whether on this plot. subject
My
to-
lord, kindly see the page number 17, my lord.
Yes.
My lord, page number 17. Where from the suit property came out, my lord.
Where from?
My lord, kindly see there are the opposite party respondent filed another title suit in the year 2013.
That is on the merits of the suit. Why should I decide that at this point?
My lord, kindly
That was
see
withdrawn.
only the para number
Their
5,
suit
my
that
lord.
was withdrawn at the time of
My
final
lord, their title is totally defect, my lord. Kindly see
That will
para.
be decided in the suit. 26/9 does not decide title.
My lord, they never claim, my lord. My lord, kindly see the 20, page 20. They did not pray for the pray for the demarcation of the suit. Only the recovery possession of the suit land dependent after evicting the removal of unauthorized fencing. Their title is perfect.
See,
From the-
please come to para 19 of your written statement, page 25. Please come to page 25, para 19. This is your written statement, I suppose. Yes. Before that, come to para 10. Page 24, para 10. Page 24, para 10 of the written statement. You have stated the suit land is not under their possession and you have underlined that also. Please come to next page, para 19.
Para 13 also.
Achha, para 13. Oh, para 13, see your statement. Please see your statement. Please read out para 13 of your written statement. Illegible?
No, my lord.
Read it out loudly in the microphone.
My lord, the property is
Can't hear you.
Survey.
Please use the microphone. Your learned junior is helping you. Take the microphone.
Survey knowing the commissioner. My lord.
Your para 13 of the written statement says that the suit property is required to be surveyed by survey knowing commissioner. And you are resisting that. Your prayer has been allowed.
My 2020
God has
file,
answered
my
your
lord.
prayer in the form of a judge.
My lord,
And
2020 file suit, my lord. It is only for the harassment, my lord.
Harassment is mutual between yourselves. The present challenge has been preferred against an order whereby the plaintiff stroke petitioner's application for appointment of a commissioner for the purpose of local investigation under Order 26 Rule 9 of the Code of Civil Procedure was refused primarily on the ground that the same would tantamount to fishing out of evidence. So next para, upon hearing learned counsel for the parties, it transpires that the suit is for perpetual injunction restraining the defendants stroke opposite parties and their men from entering into the suit land and also from disturbing the peaceful enjoyment and possession of the land by the plaintiff stroke petitioner. Push-up, relief small AA within bracket of the plaintiff claims recovery of possession of the suit land from the defendants after evicting therefrom on removal of unauthorized tin fencing on a portion thereof. Pushed up, the allegations of the plaintiff are broadly denied in the written statement. Pushed up, in paragraph number 10 of the written statement, it is averred that the suit land is not under the possession of the plaintiff, whereas in paragraph number 19 of the written statement, the defendant stroke opposite parties state that the entire land of the plaintiff is covered by pakka brick boundary wall wherein rice mill, stone crushing mill and weighbridge of the plaintiff are being run, and that the land as described in the schedule of the plaintiff is beyond the boundary wall of the plaintiff as the same does not belong to him. Full stop. More interestingly, in paragraph 13 of the written statement, the defendants opposite parties themselves have categorically stated that the suit property is required to be surveyed by a survey knowing commissioner by tallying with the title deeds and revenue records of the parties to the suit, which was the precise compass of the application for local investigation filed by the plaintiff stroke petitioner. Push up. Next para. Thus, not only is it required for a proper and complete adjudication of the suit to ascertain as to whether there has been any encroachment by the defendants on the plaintiff's land, but also to identify the exact location and contours of the property. Full stop. Next para. In fact, the defendants took opposite parties are stopped from opposing such application after having categorically averred in their own written statement that a survey knowing commissioner is required to be appointed to tally the suit property with the title deeds and revenue records of the parties to the suit. Full stop. Thus, the learned trial judge refused to exercise jurisdiction vested in him by law in rejecting the application for local investigation filed by the plaintiff stroke petitioner under Order 26 Rule 9 of the Code of Civil Procedure. Accordingly, CO 37 of 2026 is allowed on contest, thereby setting aside the impugned order bearing order number 37 dated February 19, 2026, passed by the learned civil judge, Junior Division at Alipurduar in title suit number 70 of 2020, and directing the learned trial judge to appoint a survey past commissioner for the purpose of conducting local investigation in terms of the prayers made by the plaintiff stroke petitioner in the petitioner's application under Order 26 Rule 9 of the Code of Civil Procedure. Full stop. Such appointment shall be made within a week from communication of this order to the learned trial judge. Full stop. It is expected that the commission work will be completed at the earliest, and a report shall be submitted within a month from the date of appointment of the survey past commissioner, in order to allay the apprehension of the defendants opposite parties that the suit may be unnecessarily delayed. Full stop. No orders to cause urgency.
Grateful, madam.
Thank you.
Item number 21.
21, Lordship, in this matter, Mr. Surajit Nath Mitra will be appearing on behalf of the petitioner. I only prefer not today. He will be.
Tomorrow I won't be taking up. Tomorrow I'm not keeping any. So you are sufficient.
No, I am not.
Lunchtime is over, so move it.
I am not there in this matter. I have only asked you.
Not there, you don't have any locus standi to prefer. I am dismissing what default.
Okay.
Mr. Surajit Nath Mitra is a senior advocate.
Senior advocate.
He requires some junior advocate on record to appear. So neither he can pray nor you can pray. Why should I grant an adjournment? I am dismissing for you.
No,
What is the
no.
matter about?
Order 7 Rule 11, rejection.
Rejection. You are for the opposite party.
I am for the plaintiff.
What is their base point?
Their base cause, no cause of action.
Are they enjoying any interim order?
No, actually, we have filed the suit.
No, here.
No, India.
Then after next side.
No, Lordship. I
No.
Right,
Then it is short.
can tomorrow, Lordship.
Very well. On the prayer of the petitioner, the matter is adjourned for the day. Petitioners, the matter is adjourned for the day.
Good.
Record your name.
Not here.
Yeah, and give your name also. Yes. You are Mr. Rajat Das.
No, I am for
You are Rajat Das.
I am.
What is your name?
Amit Sinha.
Give both of your names. Yes.
Man.
Don't give the Rajat Das's name. Your name.
I find him.
Yes.
Item number 22.
Yes. You are for the petitioner.
Clement.
Oh, this is this is motor.
Allow my junior to book this.
Oh, you are there also. Very good. Yes.
At the time of the disbursement, the applicant to attain the majority. So I filed a CAN 2 application, and at that time, no identity proof has been given. So a direction given to me to file a supplementary affidavit. This is supplementary.
So, should you serve a copy on the other side and come back? Somebody is appearing for the insurance company.
Already the matter has been disposed of.
Oh,
The time of the disbursement.
Oh, acha. Very good. Right. Oh, I took up the matter. So you attain majority prior to the adjudication of the appeal?
During the pendency of the appeal.
So this will facilitate you to take the money, your share of the compensation.
In the award, already the directions given that both the claimant should serve the separate accounts details. And at the time of the disbursement, it has been come to the knowledge that the applicant number 2 has already attained the majority. So
then the award has also to be corrected to that effect, because you must have been reflected as a minor.
yes.
Do you have a copy of the judgment passed in the appeal? It should be here also. There was also an order, yes. Justice Ajay Mukherjee's order.
Ajay Mukherjee.
I'll check up. You are the appellant number 2.
2.
One is your mother.
One is mother. The mother is representing the applicant number 2.
Yes, it's obvious. So what have we annexed here? Your birth certificate.
Aadhaar card.
Birth certificate you should have. Aadhaar card is good for nothing nowadays. You see what is happening to the Aadhaar card holders. So,
She has to bring the Aadhaar card only.
birth certificate you should furnish something of that sort. Your mother is also a co-applicant here.
Co-applicant.
Well, this application has been filed, but the Aadhaar card is not a document of birth date at all. Not a valid proof under any law. You could not obtain a birth certificate. It is also necessary for other aspects. No, but you have affirmed this on behalf of both. Can't you obtain a birth certificate? Just obtain a birth certificate and hand it over to court. Aadhaar card will not do. For that reason, it was adjourned also because I directed you to.
Now, on that particular, no ID card has been served in the CAN application. For that reason, the direction has been given to supply one ID proof to show that she has attained majority.
No, ID proof is different from attaining majority. Aadhaar card is your ID proof, maybe. Achha, let me.
It shows the date of birth.
That is not a conclusive proof of birth, date of birth. Birth certificate is necessary. You are born within a municipal area. Jalpaiguri, you can always obtain a birth certificate. Obtain a birth certificate and file it. I'll keep it in the next circuit. Some proof has to be there on record. A supplementary affidavit filed by the appellant today be kept on record. First of, although the appellant's prayer is innocuous, to the effect that the appellant number 2 has attained majority prior to the disposal of the appeal, only a copy of the Aadhaar card of the appellant number 2 has been annexed, which is not a conclusive proof of the date of birth. Full stop. Accordingly, leave is granted to the appellant number 2 to file a further supplementary affidavit disclosing her birth certificate and or any other conclusive proof of her date of birth. Full stop. Let the matter be listed before the next circuit. I'm sorry for this harassment, but I appreciate the difficulty, but just obtain a birth certificate. That will be necessary for other purposes also.
Much obliged.
Item number 23.
And for the opposite party number 1, Your Lordship.
Opposite, oh, that, yes. You vehemently opposed the adjournment on the last occasion.
Your Lordship.
Mr. Kunal Bhattacharya was hiding behind you.
Yes, I'm led by him, Your Lordship.
Very well. It is seen from the previous orders that the appellant stroke petitioners are consistently absent at the time of call, for sub next para. By an order dated June 16, 2026, it was recorded that none appeared for the petitioner. And although it was pointed out by learned counsel for the opposite party that the petitioner had been absent on earlier occasions, a last chance was given to the petitioner to move the matter. Full stop, next para. It was also recorded that in the event the petitioner chose to abstain from hearing on the then next occasion, that is today, ex parte orders may be passed in the absence of the petitioner. What is this application for?
Condonation of delay, section 5, Your Lordship.
Since the petitioners choose to remain absent even today at the time of call, can 1 of 2025 is dismissed for default. Consequentially, SAT 4 of 2025 is also dismissed as time barred. No orders to cost.
Grateful, Your Lordship.
Urgent certificate.
Grateful.
Only give you the names of you two, not Mr. Bhattacharya. Yes.
Item number 24 with 25.
Well, I'm for the appellants.
Yes, Mr. Pal, what is
The
that?
copies have been served now.
Copies of? Oh, affidavit of service. There was a direction.
Well, there was a direction. Well, the appeal was admitted on 21st May 2026.
What is the
my lord.
application for?
Application for stay, my lord.
The appeal is against?
Appeal is against, my lord. The trial court passed the decree in my favor, my lord.
What sort of decree?
Declaring my title as well as injuncting the defendants, my lord. That has been set aside by the appellate court.
So very well, the stay, if the stay
Stay will
operates,
revive the order of the trial court.
so then the injunction revives and your declaration of title. Very well, but Mr. Pal, you also cannot transfer the property, deal
Yes,
with the property. I'll put in that rider
My
also.
lord.
But, oh, actually, you have served.
Yes.
Affidavit of service filed to be kept on record. Despite service, none appears for the defendant. Number 3 is the main party.
Defendant number 1 and 2. Defendant number 1 is filed one appeal, and defendant number 3 filed another appeal.
So why have you made defendant number 1 and 2 pro forma?
Only because this
they
is
are
appeal
performer
against,
of-
appeal against the order of the defendant number 3. my lord.
Achha.
One suit, 2 appeal.
You have served only on one.
I've
You have
served
ser-
everyone.
Oh, all have received?
All have been served.
Despite service, none appears for the respondents. Full stop, next para. And you have sought for injunction against whom all?
All.
Very well. In view of the second appeal has already been admitted on substantial questions of law, a sufficiently strong prima facie case for grant of interim relief has been made out. Full stop. Accordingly, the operation of the impugned judgment and decree of the first appellate court shall remain stayed till disposal of the appeal. Full stop. The parties shall maintain status quo as regards nature, character, and possession of the suit property, as well as creation of third party, as well as shall remain restrained from creating any third party interest during the pendency of the appeal in respect of the suit property. Full stop. Next para. Can 1 of 2026 is disposed of accordingly. The appellant shall put in postal costs and due requisites for service of notice of the appeal on all.
No.
Better, because all.
Because both are heard and
Yes, all are. On the respondents within a fortnight from date, which of the trial court record shall be brought by special messenger at the cost of the appellant, also to be deposited within a fortnight. The appellant shall prepare and file the requisite number of informal paper books without comparing with the records within 6 weeks from the date of service of notice of arrival of the trial court records on the learned advocate for the appellant. Liberty to the parties to mention the appeal for inclusion in the list for hearing as and when the same is ready for hearing. দুটো আছে?
2 appeals to separate.
Oh wow. হ্যাঁ, তাহলে can one in both the appeals, now both the applications bearing can one in ACT number such and such and ACT number such and such are accordingly disposed of. Our stay of operation of the is a common judgment, Mr. Pal?
Common judgment. No, judgment is common but passed separately. Only if you kindly seize the judgment.
No, then the separate both have to
Same
be stayed.
judgment passed in both the appeals.
One judgment but 2 decrees.
Yes.
তাহলে যেখানে বললাম না বসো stay of operation of the judgments, the judgment and decrees passed by the first appellate court shall remain stayed, যেটা বললাম। আর শেষকালে করে দাও যেখানে liberty to mention the যেখানে বললাম the appeals for analogous hearing, for inclusion in the list for analogous hearing as and when those are ready for hearing. আর পেপার বুকস যেখানে তৈরি করার জায়গা বলেছি না, সেখানটা করে দাও যে prepare composite paper books for both the appeals, requisite number of composite paper books for both the appeals. You just include the memo of the other and the decrees.
Item number 26.
Well, I'm for the opposite part.
Who is for the opposite? Oh, you're still taking down the previous order. Yes. Yes, what is the matter?
This application is.
Yeah, Mr. Bhandari. Right. Bhandari. Yes. Yes, Mr.
I would like to
Bhandari.
interrupt once. They have sought for substitution with regard to the original opposite party number 2 and 3. But 5 has also expired.
This case has somewhat of a checkered history, my lords. During
So it will
pendency,
become
my
more
lords-
checkered because you have to implement the heirs of five
Yes,
also.
my lords.
Otherwise, we cannot pass any order in the name of a dead person.
That is the reason why, my lords, 4 cans are pending, my lords. One is for abatement, my lords.
No, for five also you have preferred.
No, my lords. 5
No.
again, my lords. I
No,
am
they
just
have
now
not.
intimated.
5 is also.
We hope, God forbid, by the time you prefer that application,
My lords, out of
no
my
other
lords,
application is required.
out of the 5 opposite parties, my lords, only, my lords, unfortunately, 1 remain.
Who remains?
Opposite party number 1.
I'm for the opposite number 1.
Rest
Give
of
him
them, my lords,
adequate protection, Mr. Paul.
have
The way
unfortunately
things are
passed away.
going. Learned counsel for the opposite party number 1 submits that the opposite party number 5 has expired in the meantime. So accordingly, on the prayer of the petitioner, the leave is granted to the petitioners to file a proper application for substitution of the heirs and legal representatives of the said deceased. Whosoever let the matter be listed in the next
My
slide.
lords, Can 4 is with regard to transposition, my lords. Transposition of petition number 2, my lords, as a party respondent, party opposite.
Mr. Bhandari, we cannot pass any order
My
in the name of it. That is the difficulty. So when substitution is to be filed, first substitutions have to be allowed, all the substitutions, then it becomes in form and then we can pass any other order.
I'm grateful.
Thank you. Huh? Next circuit. Be listed in the next circuit. Last. Grateful. Thank you.
Item number 27.
Too many matters for a day.
Milord,
Yes.
next circuit, Milord.
Very well. None appears for the, you are for the opposite party, no petitioner.
Petitioner.
Although the petitioner is represented through counsel, none appears for the opposite parties at the time of call. Let the matter stand adjourned till the next hearing. I'm putting it on them. Yes.
Grateful, Milord.
Next. No, they're not there actually.
Item number 28.
Item 20, I'm paying for now.
Petitioner. On the prayer of the petitioner, the matter is adjourned till the next circuit. You're avoiding this quote, I'm noticing. I'll remember this in the next circuit.
No, I'm.
Item number 2.
Yes.
My lord,
I know where you are engaged, so no difficulty.
My lord, I
Yes,
appear on
please.
behalf of the opposite party. On the last occasion, I beg your apologies. I couldn't make myself present.
Oh.
Yes, my lord. My lord, but there was some certain issues with the services. We have served them on the 10th itself, and the
You have
petitioners.
served them means you are the opposite party, you are saying.
Yes, we have served them. We subjected to the written affidavit in opposition. But they have provided us with the defective email ID. This is the address not found.
Keep it with
My lords. My lords, my only contention to that
Who is
effect
appealing
was.
for the petitioner?
I don't know, my lord. Yesterday, so they were. Hey, Ronak. Oh, sorry. I took it.
Yes, Mr. Ronak Ghosh is appearing.
Yes. But they are not here. I saw him a few minutes ago. I even saw Mr. Mishra a few minutes ago. My only contention was, my lord, that this court cannot proceed without hearing the condonation of delay. Neither the court below could proceed, and the court below, all the courts below had the same notion that without condonation of delay, how can we proceed with Section 27 application, where there is a time bar of 6 months, where they have come up after 5 years. In my lord may see in their applications, at no petition they have explained the
27
condonation.
of which act?
Yes, my lord, 27 of WBPT Act.
Oh,
Put it down.
So section 27 was filed before the civil court.
Primarily before the civil court against the eviction suit.
Oh, this is the matter I took up on the last occasion.
Yes, my lord. And we have judgments of Honorable Supreme Court where Supreme Court says without condonation.
Mr.
How can...
Mukherjee, right?
Yes.
Mr. Mukherjee, give Mr. Ghosh a notice. I'll keep it tomorrow.
Very well, my lord.
At the time of call, none appears for the petition.
He's here.
Yes, move the matter. Opposition, you gave a defective email ID. You gave a defective email ID. They could not serve you the opposition.
আমাদের রেডি 10 তারিখই তো করেছি
Physical.
কালকে তো বললে সার্ভ করিনি
No. My lord, I make a submission that, my lord, they were supposed to, my lord, serve me on 10. In spite of that, my lord, they served me on 15.
10th. এখানে
It bounced back.
My lord, that I don't know, my lord.
Whose
I
email
got,
ID?
my lord, the physical copy.
My lord,
the hard
it-
copy
it-
of
it-
the-
it-
Anyway, they
is
could give you a hard
given-
copy also. So you are not using a reply.
No, my lord, no.
Well, what is the matter?
My lord, kindly come to, my lord Justice Chattopadhyay's order, my lord.
Date? Don't have a brief.
My lord, my junior clerk kept
এই যে
the
আমারটা
paper
নিয়ে
inside
নাও।
the courtroom. my lord.
আমারটা নিয়ে নাও, আমারটা নিয়ে নাও।
Yes.
What is the date of that order? Give me the date.
Well, give me a second.
Yes.
এটা নয়, এটা দেখো। Yes. My lord, page 25. Page 25.
Yes.
My lord,
Just remind me the facts once, Mr. Mishra.
yes, my lord, yes.
You had argued
My
both
lord,
of you, but just remind me once.
The petitioner, my lord, filed an application under section 27 of the Premises Tenancy Act before the learned, my lord, Civil Judge Junior Division,
This was in connection with what suit?
my lord, eviction suit.
They filed an eviction suit, you filed 27.
Yes, yes, yes.
That was refused.
That was refused.
On the ground that you have to go before the, no, at that stage
No,
it was refused.
limitation.
also.
Limitation.
Limitation.
Because that was supposed to be filed within 6 months. I have filed, my lord, after a my lord, prolonged delay.
5 years.
My lord, challenging that order, my lord, I have filed a civil revision. That is, my lord, CO 151 of 2020.
That came before Justice Chattopadhyay.
Yes. My lord, while disposing this, my lord, revisional application, my lord, Justice Chattopadhyay, my lord, delegated the power, my lord, to the rent controller, and my lord, directed me to file an application before the rent controller, so that, my lord, the essential service could be restored. My lord,
No, rent controller, you are given liberty to go there.
yes,
And
to make
is
an
it-
appropriate application.
application, rent control directed to take into consideration the aspect being
Yes.
that it is unavoidable.
Yes, 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 my lord. My lord, thereafter, my lord, page 28.
Yes, 28.
My lord, I made an application, my lord, in compliance of the honorable court order.
Yes.
And my lord, before the rent controller, subdivisional magistrate, and this order was passed 29th of October 2024.
So directed.
Yes,
Then
my lord, against that order, my lord,
they preferred section 43.
they preferred their first appeal. That is, my lord, Miss Appeal 19 of 2024. No.
By the impugned order that has been decided.
Decided. That has been decided. That appeal has been decided.
36 মনে হয়।
Huh?
36 এই তো এখানে।
You
Page
annexed
36. Page 36, my lord.
No, this is certified copy, so not paginated. So what is the date of the order?
My lord, that is 3rd of May 2025.
She annexed the entire memorandum and all.
My lord, I think, my lord, the memorandum of appeal, my lord, along with the-
Certified copy of the memorandum is also.
yes, my lord, that is the, my lord, the last order, my lord, in connection with their
Yes.
second appeal.
Except
is
the
Miss
impugned
Appeal
order, I
4
can
of-
find everything else. One order is there, certified copy 24th of September 25. That was the first order.
No, my lord, the first appeal, that is.
Yes,
Miss
yes,
Appeal
that was also in first appeal, in the appeal.
2025. That was disposed of by an order dated 3rd of May 2025 by the additional district judge Tufan Ghosh.
Mr. Mishra, can you just please find out the impugned order for me
My lord,
on the
my lord.
divisional application? This is 24th September 25. You give a
Yes.
different date. This I also found. That is what I said. This is the only order I can find.
Yes, my lord. That is there, my lord. Last order, my lord.
The appeal has been entertained, stayed, impugned order stayed.
Stay, my lord.
Acha.
Stay. This is the second appeal. This order, my lord, pertains to their second appeal, my lord.
Why second appeal?
First appeal was disposed of, my lord. That is, my lord, appeal, miss appeal 2 of
Acha, where is that page number?
page, my lord. Page 36, my lord.
36 is not there. 33 is.
34, 35, 36, my lord. Order dated 3rd of May 2025, miss appeal
3rd
2
of May or June?
my lord,
2025.
yes, my lord. Miss appeal
The
2
last,
of-
second last paragraph is underlined.
Yes, my lord. The last paragraph.
That is page 33 in my copy and it's
36
merged the copies. 3rd of May.
I
or-
beg of your pardon, your
No
lordship, there
difficulty.
might be a-
Let us see what happened then in view of the sheet.
CO 244.
This appeal was filed against the same order.
My lord, this appeal was filed against the order dated, my lord, 29th of October 2024.
The present appeal has also been filed against the same order.
No, my lord.
It's my lord against 27th August, 27th August
27th of
2025.
August 2025.
Both are different, my lords. Initially, that appeal was relegated back to the rent controller again. Subsequently, again being aggrieved, the present opposite parties came back again in an appeal, where it was stayed. If I could have understood it, my lord, 27, when it was rejected on limitation, the petitioner herein came before the Honorable High Court, where without Honorable Justice Chattopadhyay, without even issuing a notices.
Civil court has dismissed on the ground of limitation.
Yes.
Justice Chattopadhyay gave liberty to go before that.
Yes, without issuing notices to the other side. Subsequently, once this order went to the rent controller, my lord, rent controller also without issuing notices or hearing the other side has passed the order. We went for an appeal. In an appeal, it was also again stated that it was again relegated back to the rent controller to take appropriate steps to decide the application in accordance with law, hearing both the sides. Now, subsequently, they were again aggrieved by the rent controller, and they again came up for an appeal under section 43, where under audio alteram partem, on hearing both the sides, for hearing both the sides.
But I think, my lord, my learned friend is not correct, my lord. Kindly have a look on order dated, my lord, 30 of December 2024, that is page 34, my lord.
Your pages will not tally with mine.
My lord,
Your
it
36 is
pertains
my
to, my lord,
33.
CO 244 of 2025.
My only point was, my lord, to say that. I'm sorry.
My lord, the order, my lord, the opening
The
line
pages
of
are
the
not
order-
tallying, Mr. Mishra. Pages are not tallying. This is order dated 11th of September 2024.
No, my lord, 30 of December 2024.
দুটো আলাদা? There are two revisional applications.
3 revisional application.
Which should I look into?
My lord, 244, CO 244.
তিনটেই ধরিয়ে দিয়ে এটা Thank you.
Page 34.
Yes, sir.
34. My lord, the first paragraph, the petitioner filed Hajira through learned lawyer, the OP filed Hajira through their learned lawyer. They are both present, my lord. Both the parties were present. In presence of both the parties, my lord, this order was passed in compliance of the Honorable Court direction.
Yes.
The last paragraph, my lord, now today, lordship got it, my lord, the last paragraph. Now today on 30 of December 2024, the court directs the landlord to comply the order of the learned SDM Tufanganj, which was given on such and such within the next 14 days and submit compliance report in person or through the lawyer on such and such. Positively, the court has also directed the landlord to file a stay order of the higher court against the judgment made by the learned SDM court on such and such date. Next date fixed on 14th of January 2025. My lord, in the meantime, they have already filed, my lord,
Under which provision of law this was passed?
my lord, section 43, my lord.
That is an appeal, not a.
Yes, my lord, they have preferred an appeal. Page 36, my lord, kindly turn up.
This order is, no, this order is passed in what? Page 34 is not passed in that appeal.
My lord, this order.
Why are you confusing
my
the
lord,
two?
This order has been passed, my lord, in connection with my application, my lord, which was filed, my lord.
Sir, only because you are confusing, Mr. Mukherjee is intervening every time. You are confused on the facts, you are confusing me also. First, you took out an application in their eviction suit.
Eviction suit. Section 27.
Application that was rejected as time barred by the the civil court. You took up revisional application.
Yes.
Justice Rai Chattopadhyay relegated you to the rent
Rent
controller.
Yes, my lord.
Filed before rent controller did not grant or granted.
Granted, my lord.
Granted against that appeal preferred.
Yes, my lord.
That appeal order is at page 36.
Page 34. Page 34. That is the first order, my lord.
Very well.
By the rent controller. My lord, that is
Again rent controller. I'm asking you, where is the order of the first appeal?
Page 36.
That is precisely what I told you.
Page 36, my lord.
So please explain the meaning of this order at page 36. This case is disposed of, a High Court order is recorded, then in view of the said order and submission, this court is of the view that both the parties have turned up before this court and accordingly, photocopy of the case will be sent to the court of rent control. It was relegated to the rent controller.
Rent controller again.
Why, on what ground? I can't find any ground in this. Anyway, it was done.
Yes.
Nobody challenged this.
Yes, my lord.
Or to follow audio alternate party.
Yes.
So after this, which order was passed by the rent controller? After page 36?
My lord, after that, my lord.
Show me the order passed by the rent
Yes,
controller after
my lord,
this.
that order was inadvertently not been annexed, my lord. Yesterday, my lord, I have handed over, my lord, the copy, my lord. To your lordship, my lord. I handed over, my lord, the.
আমাকে একটা কপি দেবে না?
Advocate generally try to make it as easy as possible for the judge.
It's
It's the other way around in your case. The more difficult it is to find, the judge gets against you. That is the difficulty. You should put it on a platter before the judge so that it's easy for him to adjudicate.
My lord,
Because we are already adjudicating other matters throughout the day. Not
Yes,
this is
yes.
not the first matter of the day.
I should have, my lord.
Should have, definitely should have. Now, there are 3 applications. My court officer is efficient enough to hand over all 3 with me
Yes.
without segregating
That
them.
was, my lord,
So I'll have to find out from the
Yes,
records.
That's the preservation problem, my lord.
Please find that out also. Ask your junior to come here this side at this stage and
My lord,
find
I
out.
am not in season of that copy.
I don't know whether this copy, where that copy is. পুরোটা দিন ওকে। ওকে দিন। আমি এখানটা খুঁজি। Date of the order, Mr. Mishra?
My lord, 27th of
Got it,
August.
got it, got it, got it. Got it. Give it back. এখানটা। Yes. Let us see this.
Yes.
So an order was passed again.
Yes, my lord. Directing, my lord, the landlord as well as the department, concert department to restore the electricity connection. Challenging.
They were given a hearing.
Yes, my lord.
Where
Both
do
the
I find
parties
it?
were present.
Let us see that from here, from the order. It should be reflected in the order that they were present also. Show me from there. It starts with CR put up today. Case records.
That was, my lord, the hearing was conducted on the basis of a put-up petition.
Without them being present. It should go on that ground.
That I have to ascertain that whether that
It
put-up
is not
petition
reflected in the order. Why
was
should I go
seen-
from your ascertainment?
The usual, my lord, the rule is that, my lord.
The usual rule is not followed. Otherwise, there would be no court or higher court.
My lord,
If the
if
usual
any
rule was
put-up-
followed everywhere.
my lord, if any
I don't
put-up
find any
petition is
reflection
placed-
of their version.
My lord, if any put-up petition is placed, my lord, the put-up petition must be seen by the other side lawyer. Well, that I have to clarify.
That much
whether
I
that-
also know, but that does not mean that it is followed always.
Yes, yes, yes.
Several matters are moved without giving
Yes,
without giving a
yes,
notice.
Yes, maybe. my lord.
How do I know that you did not do the same in this case? And it appears you have done the same that thing in this case. because there is no mention of the other side. Precisely that is what has not been done by your advocate. Appears to be so.
Should not have been done, my lord.
Wait,
Yes,
wait.
yes.
Let me see the record. And specific direction of the appeal court was audio alternate pattern to be followed. Specific direction, because probably that was not followed on the earlier occasion.
Yes.
So this time also there is no reflection that it was followed. Your learned friend takes a specific objection, it was not followed. I don't find any reflection from the order it was followed. Again, you did the same, your modus operandi was the same. Put up petition file and moved.
My lord, that my lord,
Show me from the order one single sentence, then they
yes, my
appeared.
lord, that is a put up petition.
You were very vociferous when you were placing page 34. You are very vociferous, Mr. Mishra. And you pointed out that you stressed on this, the petitioner files Hajira through learned lawyer, opposite party files Hajira through the learned lawyer on the earlier occasion.
Yes, earlier occasion.
But
Not-
where is that in this present occasion?
In the
It is not there, the same court.
Not that I have to take.
So be
instruction.
equally vociferous in this and show me where it is recorded. It is the habit of that learned judge to record, obviously.
Yes.
Because the same judge records it on the earlier occasion. You are very vociferous on this. You stressed on this twice. You said OP files Hajira through learned lawyer.
In the
Same
earlier-
judge does not record that,
in the
despite their appearance. Is it credible? Not a single reference to their objection as to maintain this limitation. Is it credible, Mr. Mishra, that
No,
they did not take
no.
this point of limitation? That was the ground on which they won before the civil court.
But if it was not seen by the other side, my lord, it is not permissible, my lord.
It is not recorded that it was seen, but they choose not to appear,
Yes.
as we record whenever we pass ex parte orders. We can appreciate the urgency, Mr. Mishra, but
Yes.
you have to overcome limitation. Why don't you find that section 5 application along with that?
Lord, on that occasion, my lord, my submission would be, my lord, that
Yes.
when, my lord, the revisional order was passed by this honorable court, my lord, they should have challenged it, my lord, that order.
No, revisional application did not permit the section 27 to be decided without section 5.
But that
Delay was not condoned.
That was only a liberty given to me, my lord, to approach the, my lord.
When was the delay condoned? It was never condoned.
But a liberty was, my lord, given.
Liberty does not vest any right. Liberty gives you the liberty to move an application that is always subject to law. This is very basic. Very basic. Sorry, I'm setting aside this order. And where is the appellate court's order? What have you challenged now? The appellate court's order?
Yes, my lord. Order dated 24th of
September.
September 2025.
So what is the mistake in this order? It has been stayed.
It has been stayed, my lord. The rain controller order has been.
Rightly. Should have been set aside. Expertise. No.
I
No
conclude
case
my
at all.
hearing.
My lord, my
The
lord,
brief
give me
facts
one-
of the-
my lord, my lord, give me one chance, my lord. So
What
that
chance?
I could.
You will get a
clarify
chance in the appeal. The appeal has not been disposed of. Waste your time in the appeal. Your Mr. Mishra, proper advice. We want to give you a proper advice. Proper advice would be to concede to the appeal, go back, file a section 5 application, take a leave from the appellate court. If you concede to the appeal, then I'll set aside the impugned order on 2 grounds. Limitation question was not considered, first. Secondly, audio alternate partem was violated. At the best, you can go back and file a section 5, accompanied by a section 5. You have to explain the entire delay. And I'll record right here and now that Justice Chattopadhyay's order did not condone the delay.
My lord, application, my lord, with regard to section 27 and section 35 of the Tenancy Act, my lord. My lord,
Premises Tenancy Act din. 27, 19. No, we also have a copy. Let her find out. Yes.
27, my lord. Subsection 2, my lord, that if the landlord got it, lordship?
Yes.
That if the landlord contravenes the provision of subsection 1, the tenant may make an application to the controller complaining of such contravention within 6 months. That is the time limit, my lord. And if the controller, my lord, subsection 3, if the controller is satisfied that the essential supply or service was cut off or withheld by the landlord or his agent, the controller may pass an order directing the landlord.
That's on interim order, power of controller to
Yes,
pass interim.
yes. Thereafter 30.
Everything is subject to the you coming within 6 months.
And thereafter 35, my lord, or repair or
You have
renovation.
preferred under 27, so 35 does not come in.
So, my lord, with regard to, my lord, Justice Chattopadhyay order, my lord, I can
I'll deal
prefer
with
an
that.
application.
I'll deal with it. The brief backdrop of the case is that the tenant stroke petitioner, is he admitted as a tenant in a suit? You have filed this eviction suit for eviction of tenant.
Yes, yes.
The tenant, that the defendant tenant in a suit for eviction, within bracket the present revisionist petitioner, bracket closed, took out an application under section 27 of the West Bengal Premises Tenancy Act 1997 for emergency restoration of electricity connection. For sub next para, the said application was dismissed by the civil court on the ground of limitation by resorting to section 27 within bracket 2 of the 1997 Act, which mandates such application to be made within 6 months from the connection being cut off by the landlord. For sub next para, the said order of the civil court was challenged by the revisionist petitioner by preferring an application under Article 227 of the Constitution of India, giving rise to CO number 151 of 2024, which was disposed of by an order dated September 11, 2024, which in the said order, comma, a coordinate bench of this court observed that subsection 2 of section 27 of the 1997 Act has provided that the rent controller would be the competent authority to accept and decide as regards complaint made in that regard by the tenant of a property, and accordingly that the court found it proper to remand back the matter to the rent controller for immediate disposal thereof by dint of a reasoned order. The order of the civil court was accordingly set aside, comma, accepting that the court shall proceed for framing of issues in the suit. While disposing of the revisional application, comma, the coordinate bench further observed that it is pertinent to note that the essential services are unavoidable, comma, in case the possession of the petitioner is undisputed in the suit property, comma, be in whatever capacity. Accordingly, comma, the rent controller was directed to take into consideration the aspect as above and determine the prayer of the petitioner in accordance with law. The rent controller was further directed to pass necessary order in that regard within a period of 2 weeks from the date of communication of a copy of the order passed by the coordinate bench. Next para, thereafter, the petitioner took out an application under section 27 before the rent controller, which was initially allowed on contest, comma, against which an appeal was preferred by the landlord stroke opposite party. Next para, in the said appeal was disposed of by remitting the matter back to the rent controller with a direction that the principle of audi alteram partem shall be adhered to. Next para, thereafter, comma, by an order dated December 30, 2024, comma, the section 27 application was moved by a put-up petition and was again allowed, comma, against which a further appeal has been preferred by the landlord stroke opposite party bearing miscellaneous appeal number 04 of 2025. By the order impugned in the present revisional application, comma, the appeal was admitted and a stay of the operation of the order passed by the rent controller on August 27, 2025, comma, which was impugned in the appeal, comma, was stayed till the disposal of the appeal. Next para, learned counsel appearing for the tenant stroke revisionist petitioner argues that in view of the specific observation made by the coordinate bench, vide order dated September 11, 2024 in CO 151 of 2024, comma, it was mandatory for the rent controller to pass a direction of restoration of electricity supply. Full stop. Learned counsel for the petitioner takes the court through the observations which have already been narrated above. Full stop. Next para. It is further submitted that after such specific direction on the rent controller to pass necessary orders for restoration of essential services, there was no further scope of the question of limitation being decided. Pushed up, it is also insinuated by learned counsel for the petitioner that by dint of the said order, the coordinate bench must be deemed to have condoned the delay in preferring the application. Pushed up, next para, learned counsel for the petitioner further submits that a notice of the put up petition and or a copy thereof was served on the learned advocate for the landlord opposite party before the rent controller. Full stop, next para. It is thus submitted that since the petitioner seeks essential services to be restored, the learned appellate court erred in law in granting stay till disposal of the appeal, thereby depriving the petitioner from essential services. Full stop, next para. Learned counsel appearing for the landlord opposite party opposes the prayer of the revisionist petitioner and points out at the outset that the application under section 27 filed by the petitioner being admittedly beyond the limitation period of 6 months as stipulated in section 27 within bracket 2, the rent controller acted without jurisdiction in allowing the same without considering the question of limitation. Pushed up. Thus, it is argued that the appellate court correctly stayed the operation of the said order and entertained the appeal. Pushed up. Next para, it is also pointed out that despite the specific direction of the appellate court at the earlier instance to comply with the odi alteram partem principle, no notice or copy of the put up petition was given to the landlord stroke opposite party prior to moving the section 27 application afresh. Full stop. Thus, the order of the controller which has been impugned in the appeal from which the present revision arises, also suffers from such illegality. Full stop. Next para. Upon hearing learned counsel for the parties, the observations made by the coordinate bench in CO 151 of 2024 appears to be the plinth of the petitioner's submission that the limitation should be deemed to have been condoned by the said direction. Full stop. Next para. However, by the said order, the coordinate bench merely observed the established position of law that essential services are unavoidable, and in case the position of the petitioner is undisputed in the suit property, be in whatever capacity. Push up. Next para. The said observation is also corroborated by section 43 of the Electricity Act, which is the relevant statute regarding essential services being provided to an occupier. Full stop. However, insofar as the observation is concerned, it is well settled that a superior forum, merely by granting liberty to a party to approach a particular forum with a particular remedy, does not have the power to condone the delay, if any, in terms of the relevant statute, in taking recourse to such remedy. Full stop. Next para. It is also not clear, it is also not reflected in the order of the coordinate bench dated September 11, 2024, passed in CO number 151 of 2024, that any effort was taken by the learned single judge in that regard to condone the delay, if any, in preferring the section 27 application. Full stop. Next para. In fact, the aspect of the section 27 application being time barred by then was not at all adverted to or considered by the coordinate bench while giving the liberty to the petitioner merely to approach the rent controller under section 27 of the 1997 Act comma, which was held to be the appropriate remedy. Full stop. Nothing further should be read into the said order, comma, let alone construing the same to be a deemed condonation of the delay in preferring the Section 27 application. Full stop. Even before the rent controller, comma, upon remand at the first instance by the appellate authority, comma, there is nothing in the order impugned in the present appeal which is from which the present revision arises, comma, that any notice or copy of the put up petition was served before moving the Section 27 application before the rent controller after remand. Full stop. In the order dated December 30, 2024, comma, there is not a whisper about any notice being given to the learned lawyer, to the opposite party landlord, or to the opposite party's lawyer. Full stop. It is merely recorded that the petitioner filed Hazira through learned lawyer. It is order date টা ভুল বললাম, order date টা আমি বললাম ডিসেম্বর, ওটা হবে October 29, 2024. In the order dated October 29, 2024 হবে ওটা, sorry, October 29. In the order dated October 29, 2024, comma, it is merely recorded that the case record was put up on that date and the petitioner filed Hazira through learned lawyer. It was further recorded that the opposite party has not taken any initiative in this regard. Full stop. It is absolutely vague as to in which regard no initiative was taken by the petitioner, comma, apparently the rent controller, meaning that such initiative was in respect of restoration of electricity connection. Full stop. Be that as it may, comma, we cannot resort to conjecture, comma, since nothing in the order dated October 29, 2024 reflects any prior notice to have been served on the opposite party landlord. Full stop. Thus, comma, prima facie, comma, the said order is vitiated on two important counts. Full stop. First, comma, it is in derogation of the specific direction by the appellate authority at the first instance to adhere to the odi alternum partem principle. Full stop. Secondly, comma, the moot question of the Section 27 application being time barred was not even considered while disposing of the same ex parte. Full stop. Next para. Thirdly, comma, even no subsequent notice was directed to be given to the petitioner, to the opposite party landlord before final disposing of the Section 27 application. Full stop. Thus, comma, a sufficiently strong prima facie case for admission of the appeal against the said order and grant of ad interim stay was made out by the petitioner before the appellate authority, comma, which justified the appellate authority passing the impugned order, entertaining such appeal and granting stay. Full stop. Hence, comma, there is no scope of interference with the impugned order. Full stop. Next para. Accordingly, comma, CO number 244 of 2025. What? Why three? Three similar. Facts are same. So next, accordingly, CO 244 of 2025 is the dates of the orders are same. Accordingly, CO 244 of 2025 is dismissed, comma, thereby affirming the order impugned therein. Full stop. Since the issues involved are similar in the other two divisional applications, comma, CO number 245 of 2025 as well as CO 246 of 2025 are also dismissed on contest, comma, thereby affirming the orders impugned respectively in the said divisional applications. Full stop. However, comma, it is expected that the appellate authority shall keep in view the exigent circumstances, comma, since the petitioner is allegedly being deprived of essential services and to dispose of the respective appeals as expeditiously as possible, comma, preferably within 1 month from the date of communication of this order to the appellate authority. urgent certified copy, no rise to cost, urgent certificate. Thank you. Pardon granted. Thank you. Next.
Item number 32.
You move the matter. Enough. Yesterday, I rebuked Mr. Rai Mahashaya for not giving a brief. Then I'll dismiss for default. Are they enjoying an interim order? On the prayer of the petitioner, the matter is adjourned for the day. Please come prepared if he does not come tomorrow. Obviously, yes. You are not vehemently opposing this. She vehemently opposes that. Yes. After Learned Counsel for the appellant, প্রত্যেকটা আলাদা order record হবে, submits that the service has not yet been completed. Accordingly, let the matter stand adjourned till the next circuit. Separate orders, same order in all the three. Which items? Board দেখিয়ে দিন তাহলে। 34, 33 থেকে 35 আগে করে, হ্যাঁ 34 বোর্ডে দেখিয়ে যাও সালাল। 35 and 39, 46, 33 to 35, 39 and 46 এগুলোতে একই অর্ডার হবে। থ্যাংক ইউ।
Item number 36.
None appears for the parties at the time of call. Let the matter stand adjourned till the next circuit.
Item number 37.
Same.
38.
Same. হয়ে গেছে।
40.
Same. You're appearing in 40. So then appeal has been admitted. This is an application. Appeal has been admitted. So I'll take it up after the vacation. After in the next circuit, it will be taken up. On the prayer of the respondent, the matter is adjourned for the day. On the prayer of the respondent, the matter is adjourned and shall next be listed in the next circuit. Next circuit. Yes, please. None appears for the parties, adjourned to the next circuit.
42.
42, my lord, I am for the appellant insurance
Yes.
company, my lord. My lord.
Yes. Yes.
42, I am for the appellant insurance company. I have already obtained stay and already deposited the entire awarded amount along with accrued interest. But in the meantime, my lord, the Reliance General Insurance Company has merged with IndusInd General Insurance Company. My lord, application has to be made. My lord, kindly grant 4 weeks time, my lord, to make that application.
You're
my lord.
sure you're for the appellant?
Yes, my lord. 42. Reliance General
42
Insurance Company.
No. 42 is not Reliance General Insurance Company. 42 is Romila Mungar versus Bajaj Alliance. So the actual appellant's advocate and the court was equally surprised.
Oh, I'm extremely sorry, my lord.
Reliance, there is no Reliance in fact in my আছে কোনো Reliance.
59 most probably.
Reliance was 40. Reliance is already adjourned till the next circuit. Yes,
Made a
someone
mistake,
appeared
my
in
lord.
40. Someone
No,
appeared
my
in
lord.
40. No
Another
difference.
matter is there, my lord. Another matter is there, my lord.
Acha, very well. When it will be called on? Yes, for the present, let us hear Mr. Vijay. Then?
I'm good.
No difficulty, yes.
Whatever you will see, in the COVID, you will see the insurance company challenging the same hour, file one appeal to the principal, since the circuit was launched here.
Acha.
So that appeal, the insurance company computation are media out here. So there just we got a launch, there it will be appeal. So one of the claiming respondent died and one is a failure. So file application, two order have been blocked. This is totally directed the public to cause the necessary amendment in the script to the appeal. Then he was divided to mention factor after 2 weeks. So you see that we can see still the same what.
So that also has to be brought, or this has to go there. That should come here because.
That was application status the main award, and we have come for enhancement.
No, but even then, both have to be heard together. So,
This is a book attention.
no meaning, no meaning.
Since you look that appeal is pending there, and that could not be because any order within 1 month or 2 let the matter.
So I'll direct this to appear along with that. No, I'll direct this to appear along with the other appeal. That will suffice. You take steps.
This matter, there's a option in the rule election. The matter can be heard in one place. So
I'll just direct because it will be very improper for me to direct the principal bench matter to be called for from there because it's maybe already before some judge. I'll direct this to be listed along with that. Wherever it is listed, either here or there, I'm not specifying this place. You take steps accordingly, either. Very well.
Month of August, next ambulance and
The circuit after the next. Very well. On the prayer of the appellant, comma, the matter is adjourned till the circuit after the next.
What is you 44?
Yes. Very well. You are for the claimant. You are for the claimant in both the matters. You cannot change. That cannot change. That will be easier to refer to. On the prayer of the claimant, the both the appeals are adjourned till the next circuit. No difficulty? Yes. Thank you.
45?
But the prayer is the same. It's not the same. I am not ready for hearing. Neither is the other side. Next circuit. In this matter, I am praying for next circuit. No, the other side is not there. I'll ride on their back. Yes. She has been right beside in the other court throughout the circuit. I've never seen her face except once. Several matters have been added. If you can physically bring her here, I'll take up. You have to physically bring her here. No. Last day appeal hearing. None appears for the respondent at the time of call. Let the matter stand over till the next circuit.
46? Oh, wait a second.
Only
47? Item number
47.
We'll give them a last chance. Because no use taking up hearing today. I won't be able to finish by tomorrow. Passing judgment at least. Affidavit of service filed today be kept on record. A copy of the paper book is also filed and is kept on record. Filed by learned counsel for the appellant and is kept on record. Tomorrow I won't be. One day will be left. So, since the respondent is unrepresented, comma, let the matter stand over till the next circuit. So, however, comma, if the respondent remains unrepresented on the next occasion when the matter is called on, it will be open to the court to consider whether to pass ex parte orders in the absence of the respondent. You are the claimant. Then it's fine. If you are the insurance company, then I won't pass such an order. Yes. Maybe next circuit they'll be up there. No, that is on circuit basis. They'll appear in the next circuit. Yes.
48.
None appears for the parties, next circuit. Adjourn to the next.
49 and 50.
Same. You're appearing? Or Article 14, yes. Article 14 of the Constitution. All matters, wherever she appears, next circuit. 49, we don't even know the item number. This is an absolute coterie. For what? You're the appellant. Oh, in one of the appeals, you're the appellant. No, 4950 has been called on. Too many matters. 4950, you are asking for next circuit. You are for the claimant. On the prayer of the claimant, let the matters stand adjourned till the next circuit. 51 whatever.
You want? My lord, I am for the claimant and also I'm praying for the next.
My lord, I am on behalf of the sole
Sole owner?
Yes, sir. Okay.
What owner?
In that case, you give me the direction to serve the copy and come. My lord, I have not found any paper.
Not found any paper means?
Nobody makes it.
We will have the paper, my lord.
Well, affidavit of service filed today by the learned advocate for the insurance company be kept on record. Full stop. Since learned counsel for the owner submits that he is not equipped with a paper book, the learned advocate for the claimant is requested to serve a copy of the paper book on her counterpart appearing for the owner. Full stop. Let the matter stand over till the next circuit. She'll give a copy to
53.
52 kilo. Oh, due to expense.
53. My lord, for item 50, I'm praying for next.
On the prayer of the claimant, appellant, the claimant stroke appellant, the matter is adjourned till the next circuit.
54.
Same. Same.
55. My lord, same thing.
Same.
56 and 57. My lord, for 56, we have already filed the CAN application, my lord. My lord, kindly let there be the direction to serve the copy of the CAN application.
56.
Yes, my lord, 56 and 57.
No, you are for which? For the claimant.
Item number 57, I am for that. And
So but you have filed the CAN in their appeal.
we have the delay in our appeal as well.
You have also filed a CAN. That is for what? So you exchange copies of the application since both of you are appearing. The learned the learned advocates appearing for the parties are requested to exchange copies of their respective applications in connection with the appeals by tomorrow. Full stop. Let the matter be listed. Let the matters be listed together under the same heading in the next circuit. Exchange copies of the applications.
Hello, body indulgence, my lord. For item number 62 also I am praying for.
Wait, you have to wait. At least that much patience you have. Call Kurun.
58.
Oh, it's same. On the prayer of the appellant. Insurance company. On the prayer of the insurance company, the matter is adjourned till the next week.
59.
59, my lord, I am for the appellant insurance company.
Yes, right. This is Reliance. Yes.
My lord, I have already obtained stay and have already deposited the entire awarded amount along with accrued interest, my lord. And in the meantime, what happened, my lord? Reliance General Insurance Company has merged with Indus in General Insurance Company. That's why I'll have
So,
to
Ms.
make an
Mukherjee,
application.
yes, you make an application. That was what I was going to. So make that application quickly so that it can be. Yes.
My lord, 4 weeks
On the
time
last
may
occasion,
kindly
their
be
submission,
granted.
on the last occasion, their submission was same, the court was recorded the same, and direction upon them to file a paper book. Till then, they did not comply the same.
My
Kindly
lord,
see
I
last
will file
order, my
the
lord.
paper book after the application is allowed. I will file the paper book with the corrected
On the last occasion, a submission
title,
was
my
same.
lord.
Court have been directed him to file the
My
application.
lord,
Till date, no,
my
neither the
lord,
application has
the
been filed,
person.
nor my lord, the paper book have been submitted. My lord, I am the claimant.
My
Kindly
lord,
Ms.
the
Mukherjee,
person who will.
on as long back as on 13th of May, this order, this liberty was given to you.
Yes, my lord.
No further
My
time.
lord, I will.
Yes, my lord.
My lord,
Grateful,
I
my
will
lord.
submit. My lord, may I submit?
Yes.
My lord, the person who has to affirm before the court, the power of attorney was not available. Now only they have got the power of attorney, and now
That's
it
your
can be
problem.
made
That's
that.
your problem. That's your company's problem, not the claimant's problem. Sorry. You are given the liberty to file on 13th of May.
Yes.
We are in, today we are on 17th of June. 1 month
My
before.
lord,
You are asking for another
my
4 weeks.
lord,
No. File within a
my
week.
lord, there
I'll give
was
you over
National
1 week.
Lok Adalat also in before that. Only last
Whatever,
Saturday,
whatever.
National.
National, we are not interested. You have to file that application within a week.
My lord, 2
And
weeks time, my
learned
lord, please.
counsel.
My lord,
Well,
2 weeks time. Kindly, my lord.
I bargained 2 weeks for you. So
As your lordship. As your lordship, my lord.
I am
learned
grateful.
counsel for the learned counsel having instruction to appear for the appellant submits that the appellant company has in the meantime been taken over by Indus Ind General Insurance Company and seeks further time to file an appropriate application in that regard. For sub next para, learned counsel for the opposite party numbers 2 to 6.
Yes, my lord.
2 to 6 files a receipt. You are filing that receipt.
My lord.
You are filing a receipt of
Yes, my
service.
lord. Last August.
Files a receipt in terms of the previous direction of this court to serve a notice on the learned advocate for the insurance company, which is kept on record. Full stop. Learned counsel for the respondents, said respondents also opposes the prayer on the ground that a similar leave was granted by a coordinate bench to the appellant on May 13, 2026, that is more than 1 month back. Whose it is submitted that neither has any application been filed nor paper books in terms of the earlier direction dated May 13, 2026, which is to the gross detriment of the interest of the claimant stroke respondents. Full stop next para. Learned counsel for the appellants cites the non-availability of the power of attorney for the purpose of filing appropriate application. Full stop be that as it may, since already 1 month's time has elapsed after the previous direction on the appellant to file an appropriate application, as a last chance to the appellant to file proper application in terms of the observations made above, a further fortnight's time is granted to the appellant. Full stop. Next para. However, in the event the appellant does not comply with the said timeline, appropriate orders may be passed in the absence of the appellant. Full stop. The appellant, no, but unless that application is allowed, they cannot file paper. That change has to be included. Very well. No further order. The matter shall next be listed before the appropriate bench in the next circuit. Please try to impress upon your client, Ms. Mukherjee, that the application is filed at the earliest.
My lord, I will.
Grateful,
Next
my lord.
week maybe I
Right.
will.
They cannot wait
I'm
indefinitely. They are
grateful, my
claimants
lord.
and they. Thank you.
Extremely grateful.
Thank
my lord.
My lord, I'm grateful, my lord.
Thank you.
Item number 60.
But in this, matter, my lord, paper book has been supplied, but it's incomplete, my lord.
My lord, paper is
Incomplete is it?
Incomplete,
No, my lord.
Examination chief is missing, my lord, from the paper book.
Paper books are prepared by the department or you?
No, my lord.
You have prepared.
Myself.
Please check up. The chief has to be there. Every piece of evidence has to be there. Learned counsel for the respondent submits that the paper book does not contain certain parts of the evidence. Who's of next para? Although learned counsel for the appellant submits that a complete paper book has been served, learned counsel for the appellant is requested to double check as to whether all the relevant papers have been incorporated in the paper book. If some papers have been omitted, leave is granted to the appellant. You are for the appellant.
My lord,
For the appellant to file a supplementary paper book incorporating the omitted documents and to give a copy thereof on the learned advocate for the respondent. Let the matter be listed in the next circuit. You please check up whatever is missing. Please incorporate that. And if you have copies of those omitted documents, you can also supply copies to him.
কোন পোর্শনটা বাকি আছে আমাকে একটু বলো।
Need not do that exercise here. You can
No, my
sit
lord.
back and do that.
My lord,
Check
stated
up.
wrongly stated.
Sixty-one.
Yes. Insurance company.
Insurance company.
None appears for the appellant at the time of call. Although the insurance company is represented through counsel, let the matter stand adjourned till the next hearing. Thank you.
62. My lord, for 62, I'm praying for next.
On the
circuit.
prayer of the appellant, the matter is adjourned till the next circuit.
63 will 64.
Second appeal. Second appeal hearing. Yes. What is the point involved? If it's a very short point, if it can be decided, then I'll hear. Otherwise,
Yes, the cross objection that has been filed, that has not been admitted till date.
I'm formally admitting that. You have filed. Who has filed the cross objection?
Respondent.
You are the respondent. You are for the. কি কইছে আবার কি পাকালো কি পাকিয়েছেন আপনি গন্ডগোল করেছেন paper books have been prepared otherwise
No.
why is it appearing for hearing then
It is not hearing, the CAN application they had filed.
hearing civil listed দিয়ে এটা hearing তুমি কারবারটা করেছো ও করেছে ওদিকে তোমাদেরকে আপনাদেরকে এটা কেন হিয়ারিং এ কেন মাথা চুল করছো অনেকবারই মাথা চুলকেছো বুঝতেই পারছি পরের দুটো কি তাই next matters you are also appearing either of you must be appearing
Yes, I am with him.
no next two matters
No.
you're not appearing anyways so direction the paper prepared stamp the office ready for hearing tanala ashe na hearing what are the applications have been decided or pending
No, pending.
what are the applications
Application for extension of interim order.
interim order is still
Interim order expired long back.
so let it appear under the appropriate heading let the matter be listed under the heading application tomorrow please come back tomorrow I'll pass formal order cross objection formal admission is necessary need not I'll record an order that the cross objection be heard along with the I'm recording it today no let it appear under the appropriate heading and pass orders কালকে করে
65.
এটা দেখি এটা রেডি ফর হিয়ারিং কিনা ফাইলটা দিব পেপার বুক কোথায় আছে পেপার তাহলে রেডি ফর হিয়ারিং none appears for the parties at the time of call let the matter stand adjourned till the next session
66.
yes Mr. Ganguly yes if it's a short point I'll take up otherwise
But the point is, my lord, the declaration suit, declaration
why are you
of
crying
1/5
you
share.
need not cry for that
Lordship.
why are you crying when you are almost on the verge of crying declaration suit
1/5 share has
are you
been,
ready
my
in the matter
lord, I am ready.
acha declaration injunction suit
Yes.
1/5 share
share, my lord. It is admittedly, my lord, the plaintiff are entitled 1/5 share of the suit property. But even then, my lord, that
you
is
are the
not-
defendant
I'm the plaintiff. On the
Acha.
order of affirmance.
yes
Even then, my lord, that has not, the suit has been, my lord, dismissed.
total
only-
suit has been dismissed so you say at least 1/5 should have been declared
Yes, my lord.
Let
On
us see
the
the
ground,
substantial
my lord, since there is no prayer for partition, it hits the section 34 of the specific relief act. Lordship kindly comes to the, my lord, the question of law which is formulated, that is page
no
1.
section 34 proviso was also
Yes, there.
because you did not ask for partition
Yes.
Consequential relief, nothing.
But my injunction prayer is there.
we are disposing of the appeal what is the necessity of partition
Lord.
prayer partition is not necessary
Yes,
prayer
lordship. And it
34
is-
proviso says only if it's essential but it could not be
Lordship, can we come back tomorrow?
come back for different matters
No.
this I am disposing of right
Lordship, I have certain facts to
mentioned that those have been not been incorporated here.
We'll
Because
come back-
Lordship,
What kind of fact?
because why I'm saying so, what is the case, Lordship, in a nutshell?
In that case, my lord,
Then
may
next
I-
second.
No, lordship, kindly, it's a very simple issue.
Was it 44
My lord,
transfer of
only,
property?
my lord, 1/5 share has been, my lord, admitted by the trial court, by the depositions of the defendants, by the first.
Because they have
For transfer property, it's a new
They have,
ground you're
they
taking.
have not challenged the transfer which has taken place prior to lodgement of the suit.
So what is the
What
difficulty there?
transfer?
Now they have claiming their 1/5 share.
They can claim the share.
No, they
Declaration-
can claim the share. It's not-
There's a bar in that. How does section 44 come in? They are seeking possession.
Many a things, Lordship.
Lordship,
What
I
many
am-
things?
I am
Declared is-
only on the point only with regard to the declaration of.
That
my
is the
1/5
only
share.
question also formulated.
Yes, lordship.
They
I'm
can
not
have.
on the other prayers, lordship. My declaration with regard to the 1/5 share, I am entitled to. That has been held by the trial court. That has been, my lord, come out during the course of the depositions of the defendant number
But
1.
still should dismiss because you did not ask for partition.
Partition.
That was affirmed by the appellate court.
That was
Mr.
affirmed by
Ganguly,
the
2-minute matter.
Nothing, my lord, nothing more.
Or section 44 of Transfer Property Act. How is it relevant here?
Lordship, that is the thing I would like to place, Lordship, because the judgment have not-
দিন না একটু ট্রান্সফার প্রপার্টি একটা স্পেসিফিক ইফেক্ট দুটোই দিন
transfer of property where আছে?
But the question of law has
Well,
not been formulated on that.
18 নতুন কিনে নিতে বলবেন 2018 এর পর অ্যামেন্ডমেন্ট হয়ে গেছে বলে লিখে দিন হ্যাঁ স্পেসিফিক রিলিফ একটা লাগবে হ্যাঁ
হয়নি, there is
63 সালের পরের তো এডিশনটা
এটা amended, 2018
এইটা নতুন ইয়েস আর
Lordship, transfer of share between.
আচ্ছা সেকশন যেটা আছে পুরনো বইটা ওটা পাঠিয়ে দিলেন নাকি ওটা দিন ততক্ষণ দেখি ওটা নিয়ে চলে গেল নাকি তাহলে ওটা দিন ততক্ষণ দেখি ইয়েস সেকশন 44 হাউ ইজ ইট
Lordship, transfer of share between the co-sharers
ইয়েস
in an undivided property. Now there has been in their plain, Lordship, certain facts have not been brought in daylight, Lordship.
No, this please read out section 44, Mr.
Lordship,
Ganguly.
there is a problem. My junior is not.
What program?
Book.
My lord, before that, my lord, let
What
me allow.
program?
My junior has not brought the book.
Problem,
Lordship.
not program.
It's a problem.
My lord, in the written statement, they agreed, my lord, that I am
No,
entitled to.
I am
1/5
trying
share.
to understand the relevance of section 44. Let us
Yes,
see.
your lordship, that is.
Transferation. Mr. Ganguly, read এটা একটু দিন তো ওনাকে অনন্দিতা ওনাকে দিন একটু মিস্টার গাঙ্গুলি আবার একটু ওদের দিতে হবে কিন্তু read out while reading you can also prepare yourself
Written statement.
that will not by itself entitle the outsider to possession
Lordship.
just because they purchase that does not entitle them per se by dint of that transfer to possession
Because
they are not asking for possession also you are asking for declaration and
I am
injunction
asking for declaration and the question of law
44
has
is
been
not relevant.
formulated on
I'm
that
disposing
only.
it off.
Yes, your lordship.
Miss Shehanovis has got the scent of blood because I indicated that I'll go in her favor.
because the quantum of land upon which Lordship, those points should be kept should not be done because the quantum of land which
No, the court, both the courts held that they
they
have
are entitled to 1/5 share.
1/5 share. That
1/5
is the
share.
finding of both the courts.
Lordship. Or if,
Despite that, the entire suit is dismissed.
Yes, your
yes, because of consequence relief and other no.
Oh, for that, so what I will do is I'll set aside the judgment of both the courts below on the ground that 1/5 is a concurrent finding by both the courts. Only ground of dismissal of the suit was 34 proviso. 34 proviso does not apply in terms of the order formulated by Justice Tandon's bench.
Akamma, judgment of Akamma.
Akamma sounds surprisingly like some other word which is which is applicable maybe to this case, to the dismissal of the suits. So that's why, so I'll not rely on any Akamma or anything. I'll rely on the section and I'll say that both the courts below should have decreed 1/5 share instead of relegating the matter back to the courts. From here, I'll declare 1/5 share and partially decree the suit to that extent. And grant injunction. What about injunction? What is your submission on injunction?
They have not prayed for any.
Injunction, I have prayed.
If they did not pray for injunction, then it would be barred by proviso to section.
Page 9, page 9,
9.
page 9 of the relief portion, Lordship.
Page 9 of?
The
Page 9, please. Paper book.
A, B, C, D, E.
No, this you cannot get. How can you get a
Permanent injunction.
permanently? They cannot sell any portion.
They're trying to restrain already what has taken place prior to lodgement of the suit.
My lord,
Some
Or I can do this.
declaration.
No,
Some
I can do
co-sharers
this.
is-
I can do this. I can grant declaratory relief and remand the matter to the trial court for the purpose of considering the grant of permanent injunction.
Lordship,
Because that has to be heard on merits.
Lordship.
That was my, because prior to lodgement of the suit, some co-sharer already transferred their share to
No,
me.
permanent injunction, I'll
That-
be the first forum then, which is
That
not proper.
is the thing, Lordship.
My affidavit also.
I'm there. I'm not representing all. Because that is the thing.
No, then it is.
1 and 2.
No, it's at the hearing stage. Notice is not served.
I'm for 1 and 2, Lordship.
Affidavit service filed to be kept on record. Full stop. The ambit of the present second appeal is short. Full stop. The both the trial court as well as the first appellate court dismissed the suit filed by the plaintiff stroke appellants for declaration of the title and permanent injunction on the ground that the suit is barred by the proviso to section 34 of the Specific Relief Act 1963 due to the plaintiffs having not prayed for the consequential relief of partition of the suit property. Push up next para. The both the courts held that the plaintiffs appellants have been successful in establishing their 1/5 share in the suit property. Full stop. However, comma, in the opinion of both the courts below, comma, the prayer for partition was essential and in the absence of the same in the plaint, comma, the proviso to section 34 is attracted. Full stop. Next para. During arguments, comma, learned counsel for the appellant places reliance on proviso যেখানে যেখানে বলছি explanation হবে আমার না sorry proviso ঠিক আছে proviso places reliance on the language of the proviso which stipulates that no court shall make any such declaration where the plaintiff, comma, being able to seek further relief than a mere declaration of title, comma, omits to do so. Full stop. Learned counsel submits that the relief, the additional relief envisaged in the proviso has to be an essential relief without which the suit would be bad in law. Full stop. However, comma, in the present case, comma, have you got a copy of Akamma, that judgment?
Yes.
This is this side. However, comma, in the present case, comma, partition was not an essential relief.
দুটো চলে গেছে।
দুজন জজের জন্য দুটো নাকি?
না, one.
Yes, is he?
হ্যাঁ, এটা AIR।
Oh, yes, দুটো আলাদা হতে পারে।
না, কিছু না।
নাম্বারিং আলাদা হতে পারে, প্যারা নাম্বার আলাদা হতে পারে। এটা তোমার ফেভারে হয়ে যেতে পারে।
No, why was Akamma relevant?
Because
Lordship,
of, I
the
think, para
consequential
19
relief
মনে হয়,
that-
because of the last
Lordship,
paragraph.
kindly one indulgence, Lordship.
There probably subsequently it was found that he was not in possession or something.
Lordship. 21, 22.
This is on a different aspect. This is Boss's judgment is.
Para 22 regarding that 34 specifically.
Paragraph 22.
আমার 22 পুরো ই হয় কিন্তু মানে এআইআর এর মধ্যে প্যারাগ্রাফ মিলে না
19.
So this is on a different proportion altogether. That if finally it is found, something is found from the evidence on appreciation of evidence, that cannot debar the suit because it is a This is a foundational point. I mean, at the inception, it has to be.
Lordship, 30 seconds. 30 seconds, Lordship. Telling us to page 50 of paper book, issue number 4, last 3, 4, 5, 6, 7, 8, 9, 10, 11th line. The 1/5 share.
Has been held.
No. What has been, they have claimed certain land belonging to another person, claiming that he is the same person.
No.
That has been.
No. That has been decided. These issues have been, my lord,
In the before
gone at the time of, my lord, the first appellate court. Only the point remains that the declaration, my lord, the partition, prayer of partition is not there. My lord, 1/5 share, it has been admittedly, my lord, held by the learned first appellate court and the trial court. They have also in their written statement and the deposition said so. That is what, my lord, my simple.
1/5 share of which land?
The declaration can be made. Which land that thereafter, my lord, that will be decided.
In such premise, the court believes that the plaintiffs jointly are the owners of 1/5 share of the property.
That part is
belonging to Surendra and Chittaranjan Kaur, alias Chittaranjan. In addition to the aforesaid, since the plaintiffs, owing to the aforesaid findings, could not prove the schedule of the plaint.
so which land? That's the problem.
That it is not in a position to advance. No, Mr. Hanovis, it is also found at page 51, just before the bold portion. In addition to the aforesaid, since the plaintiffs, owing to the aforesaid findings, could not prove the schedule to the plaint, then the next word is illegible.
No, my lord, my submission, my lord, before that, lordship kindly comes. My lord, what happened? The suit land, my lord, of the father, my lord, has been partitioned, initially partitioned between the 4 brothers.
So that's your case.
There were 2 sisters also, but the suit land was partitioned between 4 brothers. 1 brother died. Now, lordship, the 3 brothers, 2 sisters come in.
There are other grounds also.
My lord, those have gone. Those all have gone, my lord, in the appellate court. If your lordship's kindly comes to the, my lord, the finding of the appellate court.
Let us see. Yes.
Appellate court peculiarly, lordship went to that portion. The consequence was not played, so
from page,
did not enter into the merit even.
Page 84 onwards is these are the findings of the appellate court. And lastly, my lord,
appellate court did not enter into the merit.
সেই দিয়েছে আরে ছুঁড়ে মারতে বলো ওটা আমার বেয়ারাক লাগে
see, my lord, page 85, last paragraph, lordship, see.
Page 88, para 27, lordship.
No, page 87, para 24, please come, Ms. Han. In this maze of devolution, whatever, individual shares are extremely difficult to ascertain, and in my view, the learned trial judge was justified to hold that although the plaintiff is entitled to 1/5 share, it is difficult to ascertain whether such property was actually the property described in the to be the.
That's the problem, lordship.
Let us see what is the finding on this. This has not been reversed.
Para 27 also, lordship.
The para 27 is
all of a sudden he was to that specifically paid.
Since the sisters. What maze and all obsession with maze? Confusing, judge. But if the suit is dismissed on the ground of 34 proviso, then the courts have to find that they had share in the property. Otherwise, that would be irrelevant. Where does the question of partition come? Then 1/5 share.
That part is
1/5 share remains.
But of which land? The question is, Lord, Shoilen and Chittaranjan.
No, No, Shoilen and Shoilen
Elias
alias
Chittoranjan,
Chittoranjan.
not Anne.
Alias Chittoranjan.
Elias.
There's the,
You have not studied at all.
actually just.
They have studied a little bit. Mr. Bhattacharya has not studied at all. You have not studied at all. Only the ladies have studied. A little bit.
That was the reason, Lordship, I was asking for one.
In this matter.
This
I don't have any bias for ladies. But in this matter, the ladies have studied. None of you have studied. This is very apparent from your facial expressions.
I was praying for their adjournment regarding this thing, Lordship, to go detail.
Tomorrow, taking up second appeal. Very well, we'll take up tomorrow. We'll have to look into this. Please come more prepared. Just pinpoint the exact paragraphs where the court has found that you are. I'll take up tomorrow.
My lord, that 1/5, my lord. Your
1/5,
lordship
only
has-
on 1/5.
Yes, your lordship.
1/5, only on that.
1/5.
If you can establish 1/5, then the rest follows.
Yes,
Is
1/5.
No,
is
1/5 regarding the suit property, because there is some, page 87, there is some doubt. That is what I was reading out. And para 27 also. No, sorry, not 27. Not 27, Mr. Ganguly, please, but para 24 at page 87. Please look into that.
Yes.
Means
The
of
thing
dissolution,
is that
etc.
Shoilen Kaur alias Chittoranjan Kaur,
Yes.
he inherited some property from his father and he purchased some property from his some outsider, but he died intestate.
More serious. The judge, in my view, the learned trial judge was justified to hold that although plaintiff is entitled to 1/5 share of the property left behind by Shoilen alias Chittoranjan, it is difficult to ascertain whether such property was actually the property described to be the suit property. So you have 1/5 share in Shoilen's property.
Yes.
Whether the suit property is Shoilen's property, that
Yes,
is in
your
doubt.
lordship. So property is Shoilen's property.
It is difficult to ascertain whether such property was
Well,
actually property described to be suit.
My lord, my lord, then lordship, if your lordship kindly comes to the plaint once.
No. It carries on. I mean, you said that both the courts found that you have 1/5 share. Both the courts have found that you have 1/5 share in Chittoranjan's property. But there is a doubt expressed that whether that is the suit property. The identity of the suit property is in question. Then the appellate court moves to this partition thing. Achha, let us see para 26 also. Yet another.
There are 26.
Page 87. This is a contradictory finding actually for 24 and 26. Yes, sir. যা পাওয়া যাচ্ছে তাই রে। ওটা কত 18 ছিল, তারপর বোধহয় এগোয়নি সময়ের জন্য কিনে নিতে বলতে হবে তারা নতুন এডিশন। আপাতত এটা থাকে, এটা চেয়ে 18 চেয়ে 19 ভালো, 19 থেকে 20 পেলে 20 ভালো।
আরে দিয়েছি তো এটা। না এটা দেওয়া দিয়েছি।
Please look into this and satisfy the court that 1/5 share was declared actually. Affidavit of service filed today be kept on record. First of due to paucity of time, the matter cannot be concluded today. Let the matter be listed tomorrow. Most of the matters have been adjourned today, so tomorrow I'll be taking up this matter.
Grateful.
কালকে নতুন একটা কন্টেম্প গুলো আসবে, কন্টেম্প গুলো দিতে হবে। অন্য কন্টেম্প তারা 10টা দেবেন, 10টা দেবেন, 10টাই দেবেন, আর 20টা দিতে হবে না। বলেছিলাম 20টা দিতে রেজিস্ট্রার সাহেব, কিন্তু 10টাই দেবেন। যেগুলো পাঠিয়েছে, যটা পাঠিয়েছে দিয়ে দেবেন। আর পাঠাতে পারেন, আর পাঠাতেন না। কালকেও আর দেবো, পরশু দিন আর দেবো না। পরশু 3-4টে ম্যাটার রাখবো, পরশু প্রায় কিছু রাখবোই না।